at Loyola Marymount University. Our director, Dr. Roberto DeLoro, couldn't be here with us today. He is in Rome delivering a paper to the Pontifical Academy. That trumped us, I'm sorry. We offer a Master of Arts in Bioethics here at Loyola Marymount University. Our students include physicians, nurses, social workers, teachers, all kinds of students who come here for 2 years in the evenings, twice a week, to study the foundations of the philosophical foundations of bioethics. Bioethics at the beginning of life, bioethics at the end of life, bioethics in the law, research ethics, the history of ethical discourse. And I'm telling you this not just as a commercial for our program. There are brochures in the back if you're interested, but because LMU is not attached to a hospital. And that means that our students don't fully appreciate the on-the-ground clinical expertise that you all bring to what you do. So I want you to know that LMU, we appreciate our association with SCBCC. We understand the importance of what you do. We appreciate your hard work. And we are very happy to host and co-host this Ronald B. Miller Memorial Conference. And on behalf of Dr. DeLoro and myself, the Institute and LMU, welcome to what is going to be an interesting and informative morning. And it is now my pleasure to introduce Mrs. Irene Morris Miller.
Good morning. How many of you were here 5 years ago when, as you arrived, the alarms were going off and, oh, it was just pandemonium for like 20 or 30 minutes? Does anyone remember that? That was Ron. We had arrived early. We drove up from Irvine and arrived a half an hour early. And so we were upstairs and we went to the lounge area. And he was a little restless, and so he had to look around. And he saw this patio that had a sculpture outside and decided to open the door and look at it. And it set off the fire alarm. So in the meantime, food service is trying to get up on the elevators. The elevators aren't running because of the fire alarm. And I don't think the escalator worked either. So they're getting frustrated. It takes 20 or 30 minutes before security can come to turn the alarm off. And everybody is wondering, where is breakfast? So the whole thing was delayed for another half hour. And here it was, it was like all hell broke loose. Typical Ron, always causing a ruckus, like wherever he went, he would always make his presence known. He was a brilliant man, had many new ideas he presented before their time. He made people think outside the box. Holst was one he had worked on for a long time, trying to get it right. But the one thing he rarely talked about was, how did Ron lose his fingers? Where? When? How? He was not born that way. He was just 18, home for the summer, with his parents and 2 younger sisters who lived in LA. He always had a summer job. Even at age 14, he figured out a way to get free pony rides. All he wanted by stacking hay and leading a child riding a pony around a ring. And he was paid 10 cents a week. This was 1947. But this summer of 1951, it would be a job working in the oil fields of Castaic, California. It paid better, $3 an hour. One fateful day, he approached the wooden platform of the oil rig. A door had been left open over the moving machinery parts. His right hand extended into the moving gears, and 3 middle fingers were mangled. An observant coworker, an older gentleman, quickly placed a towel over Ron's bleeding hand and would not let him look at it because he knew how bad it was. Doctors wanted to amputate his hand at the wrist, but Ron said, "I need to call my dad." His father called friends to determine who the best hand surgeon was in Los Angeles, and Ron was quickly transferred to Good Samaritan Hospital, and a Dr. Norton Nichols saved his right thumb and little finger to make a claw. He was in the hospital for 3 weeks. The following summer, he had more surgery on his hand. He was now a student at Princeton, and it was the summer of 1952, and that was when he decided he wanted to be a doctor. Had this accident not happened, who knows what path he might have taken instead. For your information, the oil company paid his medical bills, but no other compensation. I don't think that would happen today. Here he was in the prime of life, age 18, having to learn how to use this claw hand all over again. Previously, he had learned to type, and I believe he said he could type 100 words per minute, which I was astounded. And he was a competitive tennis player. He and his father used to compete all the time with one another. His father even bought him a left-handed typewriter, but he said his brain could never really adapt. What a challenge. Medical school with half a hand. He did it, and he excelled. He figured out a way to rise above it all. Tenacious. Drove us all crazy. But we loved him, as did his family, patients, and colleagues. He would be so honored to have this lecture series named after him. Thank you, Paul.
Can you all hear me okay? Good morning, and welcome to our conference on the subject of the medical hold, or more properly, the medical incapacity hold. I'm Paul Schneider, the chairman of the Southern California Bioethics Committee Consortium, SCBCC. And on behalf of our board and our members, it's my pleasure to welcome you to this conference. Let me begin with some thank yous. First, I'd like to thank our current board members for their voluntary service to our organization, and I really mean voluntary, both in terms of preparing for this conference and regular duties. So I'm going to ask each board member who could be here this morning to stand as I call their name, and we'll give them a round of applause all together. Teresa Drought? Where's Teresa? Stand up, Teresa. Kendra Gorlitsky-Flegel. Stand up, Kendra. Ken Landis, Grace Wee, and Chris Wilson. Thank you to all of you. You'll be seeing more from each of them as we proceed this morning. Additionally, we would like to thank those who couldn't be here this morning. You may know some of these folks: Stuart Finder, Jim Hornstein, Roberto DeLoro, and Neil Wenger. My thanks to each of you individually and to the constituent organizations for which you represent. I literally could not do this work without you. Second, let me thank Roberto DeLoro and LMU, Bioethics Institute, for hosting us this morning. This is really a beautiful venue. It's our second time here. We're so happy to be in this place. And let me thank Helena Olivieri. Stand up, Helena. Give a wave. Who has been my partner throughout all the planning stages. She did a great job. Next, let me thank all the speakers who we're so lucky to have gathered together this morning. I'm not going to introduce them this morning because you're going to hear introductions before each talk. But let me just say that I think, as far as I understand it, you are going to hear the state of the art from these people. I don't expect that there's really anyone in Southern California who knows this material better than these people. And I actually owe each one of them more of a debt of gratitude than the very humble gift, which I'll be giving them later, okay? I owe them a lot for doing this conference. Lastly, I want to thank Tiffany Zwerkel from UCLA, who sent me her undergraduate bioethics students, many of whom are in the audience. Let me see you guys stand up. Thank you very much. And cool. And these young folks have already helped me usher for this morning and staff the table. And they're going to be going up and down with 3x5 cards later on if anybody wants to write down questions. So who knows what this artwork is? Anyone recognize it? Say Marcia again. Oh, you get the prize. Bingo. She said the unicorn tapestry in the cloisters in New York City. That's correct. It's part of the Metropolitan Museum, and it's a gorgeous piece. It's a set of like 7. It's about 500 years old. Nobody knows exactly where it was made. They think it's Flemish. And this particular one of the set is called the Unicorn in Captivity. And why am I showing it to you? Because a few days ago, I was on the phone with a colleague in another state. She's a psychiatrist, and I told her what the subject of this morning's conference was, and she said, "The medical hold? You mean the mythical medical hold?" And I said, "Right. That's the one, except I think we're inventing it, Cindy." And she said, "Oh." So I think, folks, we're going on a unicorn hunt this morning. And what I hope is that over the course of all these talks, that I sort of am able, and that the other speakers are able to convince you, maybe not that the unicorn exists, but that it should exist, okay? Or that we should make it exist. However, to some people, the idea of what we're talking about this morning is a non-starter. After all, in California, we have standing legislation for something called a mental health hold or a psychiatric hold. Here it's called an LPS hold. And for its first 72 hours, it's called a 5150. And shouldn't that be enough? Right? If indeed a confused patient needs to be held against his or her will in a hospital for safety's sake, how narrow or how broad ought to be the justification for doing so? Is it not appropriate to set the barometer at the most severe forms of psychiatric impairment and disability so that we maximize the liberty of individuals and respect their personhood? As I was taught in med school some 30 years ago, if you want to write a psych hold, your patient ought to not know to pick food out of the trash when hungry and not know to crawl in from the rain when getting rained upon. If they don't know those things, then you can write a psych hold. Other than that, you can't. And those kind of strict criteria do indeed maximize freedom while minimizing forced hospitalization. To be fair, a variety of interpretations exist about what constitutes grave psychiatric disability. And what I was taught 30 years ago only represents one end of the spectrum of philosophies about it. However, to one who does espouse this philosophy in LA, particularly commonly held here in Los Angeles, the idea of a medical hold would likely be inappropriate to those folks. Why so? Because confused as they might be, as lacking in decision-making capacity as they might be, and medically ill as they might be, they might well know to crawl in out of the rain. But if one does adopt such a stringent set of criteria as the only mechanism by which to hold patients in the hospital, one will have to encounter the ethical problems that will ensue. Patients who are somewhat less gravely psychiatrically disabled will leave the hospital and refuse treatment, though not able to fully understand the nature of their refusal and its consequences. And of really profound importance to the subject of today's conference, patients whose lack of capacity to understand their own circumstances stems not from psychiatric disease, but from medical disease, because of the LPS statute and its interpretations and implementation, they will not be readily detainable in the hospital at all. They'll be allowed to go. To note, in medical parlance now, dementia and delirium from medical disorders, while conditions that affect cognition and mental state, are not considered to be psychiatric disorders at all, but medical disorders. Our conference today stems from the ethics position that doing medical beneficence and non-maleficence require us as healthcare providers to attempt to minimize the harms that come from incapacitated patients refusing treatment and walking out into harm's way in the big city. Clearly, not all patient harms are foreseeable or preventable, but when they are indeed foreseeable and preventable and directly related to a patient's inability to understand a medical reality, are we not ethically obligated to act? Moreover, the mere participation in or condoning of allowing such a patient to leave the relative safety of the hospital leaves many providers with the sense of moral distress that they have been influenced by various factors to do the wrong thing in order to satisfy a set of criteria external to the doctor-patient relationship. Today's conference examines how different professional disciplines, institutions, and individuals have confronted this question and responded to it. To be sure, many hospitals here and across America have evolved different individual systems of preventing confused but unholdable people from leaving against medical advice over the years. And so it's appropriate to consider whether there are more ethical or more effective ways of doing so. And to be clear, it is not my, or I think any of our speakers' impressions that the medical hold should represent a mechanism to hold all sorts of confused but technically unholdable patients, but only a very specific subset of them. Specifically, it is not our intention that the medical hold becomes a backup plan for holding psychotic or depressed people, for which standard mental health holds are appropriate. It is my hope that we can develop a consensus standard for our region regarding how to respond to the challenge of medically ill, incapacitated, but unholdable patients, and today's conference will to some degree represent a turning point in practice, that we will find the unicorn. Today's conference is dedicated in memory of Dr. Ron Miller, one of the founding members of SCBCC, and an incredibly devoted participant of all manner of ethics education events, and especially consortium. As all of us who knew him would attest, that if it were at all in his power, Ron would do anything to actually be here this morning. But settling for the next best thing, we are very grateful to his wife, Irene Morris Miller, for having opened our meeting with some memories of Ron's life and work. Thank you, Irene. And thank you all for attending this conference. At this point, let me call up Grace Wee, who will introduce our first speaker.
Good morning. I have the honor to introduce Dr. Eric Chung. He's a psychiatrist at UCLA. And at UCLA, he serves as the Director of Emergency Psychiatric Consultation Service. He's also the Chief Quality Officer for the Department of Psychiatry. He's uniquely qualified, I think, to speak on the topic of our conference today. He went to medical school at Albany Medical College in New York and graduated with a distinction in bioethics. He did his residency at UCLA, where he also served as the chief resident. Dr. Chung's professional interests include the delivery of mental health services. He is currently chair of the EMS LA County Commission, where he's intensely interested in how mental health services are delivered, especially in the emergency situation. He's also very interested in psychiatric ethics, specifically in the area of the ethics of stimulant use in academics, or maybe more commonly called academic doping, or as a term that I learned very recently, cosmetic pharmacology. We really want to thank you, Dr. Chung, for lending your expertise, sharing with us your experiences from UCLA. And his off time, Dr. Chung is an avid surfer. And without further ado, thank you again, Dr. Chung. The floor is yours.
I want to thank Dr. Schneider and thank the consortium for inviting me today. I'm very pleased to speak on behalf of this topic to you. I was the primary author of what we call the Medical Incapacity Hold at UCLA, and will share with you my experiences in developing this policy. I think it's probably prudent to say a few words of how I wound up being the primary author of such a policy. In sum, it was over years of experience of being on the side of the phone call from a psychiatry resident or being a psychiatry resident myself in dealing with situations that we're going to look at where they called up and said, got this patient, she's trying to leave. I don't think she meets criteria for an LPS hold, but the team can't let her go. How are we going to keep this patient in the hospital? And all the kinds of confusion and problems that would arise from that particular scenario. Just a vignette to start, fairly classic, fairly simple. Cindy's a 50-year-old female with no past psychiatric history. Last night, she had a surgical resection of a brain tumor. She's in the ICU. She wakes up severely confused and scared. She's perplexed about the head dressing, the wires, the tubes connected to her body. She says frantically to the nurse, "Why am I here? Who are you? Let me go. I have to go to work. I think I'm late." The nurse works as much as she can to redirect the patient, gets her to stay, but an hour later, Cindy's insisting on walking out of the ICU. The primary physician is paged to see Cindy. Cindy has delirium following the surgery. She lacks understanding of her brain surgery. She doesn't know what the risk would be of leaving and walking out of the hospital. And per the medical team, there would be significant and serious medical complications if she left. Cindy starts walking towards the elevator. Staff, everybody in the hospital knows that this is a serious problem and agree that she has to be kept from leaving the hospital, what we call elopement. But they are unsure whether it is legal to detain the patient against her will. Here's the problem statement. Patients who lack decisional capacity due to a medical illness may attempt to leave the hospital, thereby declining their care despite grave risks to themselves. And it's not clear what is the best legal or clinical mechanism to detain such patients. Can the what I call the medically incapacitated patient, for short, be detained in the hospital against her will? Now, there's a number of different things that go into the consideration of whether you can keep a patient in the hospital against her will. Dr. Schneider was foreshadowing some of those. One certainly is whether the patient meets criteria for what we call a 5150 or an LPS hold. Another one that is not written here is whether the patient has been deemed legally competent by a court. But what is most critical in these settings is the evaluation of the patient's decisional capacity. Patients who have capacity to understand their medical illness and the risks of declining care can and should be allowed to leave the hospital, what we call against medical advice. The doctors may advise against it, but if she understands the problem, if she knows she had brain surgery and she could die if she left the hospital, in short, by common law, she should be allowed to leave the hospital and retain that right to self-determination. I think we're going to hear more about that in the next talk. That one is, I think, less of a problem, at least from my perspective, when I get called into these settings. It's the patient who doesn't have capacity due to things like severe cognitive impairment or delirium, frequently due to something like a traumatic brain injury, a stroke, a seizure, infection, cancer. What do you do with the patient who doesn't have capacity but still insists on leaving? And you can look into the literature to find that up to 40% of patients who are hospitalized might demonstrate compromised decisional capacity, depending on the setting and the illness. And it's not clear what proportion of those patients will attempt to leave the hospital. That hasn't really been characterized. In our hospital, we looked at data for about a year's time and found that maybe 2 or so patients per month don't have capacity and try to leave and run into these settings where they're at the elevator and security has been called and we're dealing with what is otherwise called an agitated or code gray patient in our hospital. So there is no clear protocol for the patient who lacks capacity in this setting. And when the patient is medically incapacitated but attempts to leave despite this grave risk, that physician who got called to evaluate Cindy has really 3 different options available to him or her. 1, let Cindy go. Allow Cindy to discharge AMA. 2, request that a psychiatrist come in and place an involuntary psychiatric hold if that kind of resource is even available in the hospital. 3, just detain Cindy. And we'll talk about what are the problems with each of these. Should we let Cindy go and leave the hospital? Answer is no, for a number of different reasons. It's ethically wrong. As physicians, we have a duty to protect patients from harm and act in the patient's best interest. From a risk perspective, that there's a lot of risk involved in this, of negligence, of malpractice, and if Cindy were to die as she walks across the street with her, post-operative brain cancer, one might think that you could be liable for wrongful death. Most physicians don't struggle with this one. Second one was psychiatric evaluation of Cindy at the elevator. And this was very commonly pursued, and I think is the most common mechanism that is used, as far as my understanding goes, in hospitals across the country. When a psychiatry consultant is available, they're often drawn into these settings to evaluate and, if possible, place an involuntary hold, in part because there are laws on the books that you can refer to. This is a legal thing if the patient meets criteria. All states have civil commitment laws for involuntarily detaining patients who are a danger to self or others. And in certain states, gravely disabled is also a criteria, the inability to provide food, clothing, or shelter for oneself. And they all specify that you can place this type of involuntary civil commitment due to a mental illness. Mental illness is left vague and undefined. As Paul was mentioning, it is usually interpreted to be things that we consider primary psychiatric illnesses, the stuff you would think about: schizophrenia, bipolar disorder, depression. No state has a law that addresses detainment of the medically incapacitated patient. Psychiatrists don't want to use civil commitment laws. I don't want to use civil commitment laws for patients who don't have what we consider to be psychiatric or mental illness. Is simply not appropriate. In fact, I dare say it's illegal to do that. Here are reasons why using the what's called California Welfares and Institution Code 5150, which is the LPS law, why it's not appropriate. I just said that the legal criteria are not met, but here are other reasons. The 5150 law implies that the patient placed on that hold should be transported to an LPS designated facility for further psychiatric evaluation and treatment. Patients like Cindy don't need that kind of care. Psychiatric holds are time limited and involve judicial proceedings. Some of you might be aware that as 72 hours elapses, if the patient still is considered a danger to self or others or gravely disabled, they can be placed on a 14-day hold. And at the point of 14-day hold, the patient gets a whole host of patient's rights appropriately, such as being able to contest that hold. And that can happen in an initial hearing called a probable cause hearing in the hospital, where a court appointee comes in to represent the patient. A patient's rights advocate meets with somebody who's on a hold and argues why that patient should leave before a court-appointed officer. Further, if that patient would contest what was the finding of that hold to keep the person in the hospital, they can go downtown and stand before a judge and have a writ hearing to contest in front of them. Imagine somebody like Cindy placed on a 14-day hold with her post-operative delirium, going downtown and contesting her hold. It's simply not appropriate. Psychiatric holds do not authorize medical treatment without consent, which is oftentimes the crux of the issue. Cindy needs treatment. She needs to be kept in the hospital in order to get that treatment. Psychiatric holds don't authorize that. And discharge planning options can be negatively impacted by the presence of a psychiatric hold. It's an unfortunate truth that a patient who has a psychiatric condition or who has thought to have a psychiatric condition, perhaps implied by the presence of a psychiatric hold, may be disqualified from certain types of placements, such as skilled nursing facilities, aftercare programs, rehabilitation services. Medical conservatorship is a distinct and different pathway than what is considered psychiatric or LPS conservatorship. Medical conservatorship exists under probate code, not LPS or welfare's institution code, and is appropriate for patients who are chronically medically ill or medically disabled, but it can be complicated to pursue medical conservatorship in the presence of a psychiatric hold. In fact, it is complicated. We've been in endless amounts of battles where we pursue medical conservatorship with a patient who had been on a psychiatric hold, only to get 60 days out in that process, and they say, this should be an LPS court, and start all over again. And then LPS court to say, this should be in probate court. So, option 3, just detain Cindy. Can physicians just order the patient to be detained? I gather that this probably happens in a lot of hospitals who haven't set up a mechanism for doing this, and it's probably the least harm way to go. But in our experience, the staff won't do it. Staff in our hospital who may be somewhat rule bound won't detain a patient because they say, tell me the law that lets me detain this patient. Tell me the grounds upon which I can do this, and won't be charged with false imprisonment. I can't show them that law. It doesn't exist. And so security won't do it. They don't want to be a party to a suit for false imprisonment. Physicians won't do it. Nurses won't do it. The sitter won't do it, or a constant observation aide won't do it. And really, what is considered the standard of practice for detaining such a patient? How would you stand in front of a court of law and explain why you held the patient and what the community standard for that really is? Bottom line, after considering all these things, is that we needed a hospital policy to address the involuntary hospitalization of the medically incapacitated patient. So, getting into what we did. It was a one-year process, and it was actually instigated by lead nurses, charge nurses on floors that deal with neurotrauma, that deal with liver illness and hepatic encephalopathy, which is confusion due to toxic metabolites that aren't being cleared by the liver. And they said, this is happening too much. And we kept getting drawn into these things. And in situations like Cindy, where the psychiatrist goes to the elevator and everybody's looking at each other like, are you going to place a hold? Psychiatrists would say something like, let's see if we can get Cindy back to her room and get her to stay. And if she tries to leave again, call me and I'll place a hold. And that's how you have this repetitive scenario of the agitated patient trying to leave. Just to give you a description of what UCLA looks like, we have 770 medical surgical beds in 2 different hospitals, the Westwood campus and the Santa Monica Hospital campus. And we brought stakeholders from all kinds of different disciplines to this because this really crosses all these different parties: psychiatry, the chief medical officers, nursing directors, security, patients' rights office, internal medicine, neurology, ethics. Leaders from all of these different disciplines came and engaged in this one-year process. We started by looking at what are our policies on the books. Does anything in our policies say something about what we should do in these settings? And we, of course, looked at the laws that are on the books. Is there any law in the state of California or a federal law that says something about the medically incapacitated patient and detaining that patient in the hospital to get treatment? The answer was no. We called our colleagues across the county, different hospitals, and said, what do you do? Do you have a policy? How do you handle this? And got radio silence. We called all the UCs across the state and said, what do you do? And they said, I don't know, what do you do? And we know this is a problem. And we said, well, we're thinking about doing a policy. And they said, I don't know about that. Maybe, but they really were worried about this. Bottom line is, as we played out all the different factors here, our hospital decided that it was in our physician's interest and in the patient's best interest to write a policy because this was happening anyway. And that at least if we had something on the books where we had carefully thought about what to do, we could point to that policy. And this is how you get policy when you don't have law, is that at least you've articulated what a standard of care will be in your hospital, even if it can be potentially faulted later down the line. So we all adhere to the same standard, and we've thought about it carefully. Before I launch into what our actual policy looks like, this is what was happening prior to the implementation of what we call the Medical Incapacity Hold. This is a survey of all the involuntary psychiatric holds that were placed at UCLA pre-MIH, Medical Incapacity Hold. And I had 2 of my astute residents look to see what was the appropriateness of placing the hold. So for this patient who was in the ICU, patients like Cindy, who wound up on a psychiatric hold, 78% of them were actually appropriately placed on a psychiatric hold. There was a psychiatric condition that one could point to that would justify the placement of that 5150. 18% of them were inappropriate. There was no psychiatric condition that would have, legally authorized the placement of the hold. And there was some disagreement about 4% where it could have gone either way. It was that 18% that we were particularly worried about. These were the conditions involved with prior to the medical incapacity hold, and you can see the conditions that were involved related to the ones that were inappropriate, so that 18%. And, it involved the usual stuff: intracranial pathology, bleeds, tumors, infection, major neurocognitive disorders, substance-induced syndromes, which generally fall outside of 5150 law in this county, postoperative complications, epilepsy, metabolic disturbances. Okay. For the vast majority of these, most people would say these are medical, not psychiatric. Okay, now we're going to go through just a couple of slides about what we do, and these were actually part of the staff education that we rolled out system-wide. So what is a medical incapacity hold? A medical incapacity hold is a physician order which permits the involuntary detainment of a patient in one of our hospitals who meets these criteria. The patient does not have capacity to understand the risks of leaving the hospital and declining care. The patient is making attempts or threats to leave the hospital, which would then jeopardize that patient's health seriously. The patient is not on a psychiatric hold and does not meet criteria for a psychiatric hold. Those are the baseline criteria. How does this differ from a 5150? Well, a psychiatric holder of 5150 permits a person who has been authorized, designated by the County of LA, to involuntarily detain that patient under these criteria. He or she poses a danger to self, others, or is gravely disabled, due to a mental disorder, not a medical disorder. It was important for our staff to really clearly understand that. Who can place a medical incapacity hold? Any UCLA physician who is treating a patient in Reagan or Santa Monica Hospital can place a medical incapacity hold by writing an order in our electronic medical record system and documenting appropriately. A psychiatric hold, by contrast, can only be placed by an LPS certified provider. How long does a medical incapacity hold last? We had to come up with a time frame, and we decided on a max of 24 hours, and that it could be renewed if the patient continues to demonstrate the criteria that authorize the hold, the lack of capacity. And we also established that when the patient has been on a medical incapacity hold for greater than 72 hours, we would like this situation to be looked at by another person, another entity, or another provider. And initially, we said that could be ethics, risk management, or the chief medical officer. More recently, we're revising that to say any second consulting physician can participate in that 72-hour evaluation. We created this flowchart, this decision algorithm, to help people work through the difference between psychiatric hold and capacity assessment and medical incapacity hold. The bottom line is that if you work through this chart, you're going to arrive at one of three decisions. The ordering of, in the gray, ordering of an involuntary psychiatric hold for patients who meet that criteria, ordering of a medical incapacity hold for patients who don't have capacity, or allowing discharge AMA for patients who do have capacity. And I won't spend too much time on this just to be respectful of the other speakers, but we can come back to it. Does a patient on a medical incapacity hold have rights? And we put this in our policy very specifically. Yes, the medical incapacity hold simply limits the ability of the patient to leave the hospital and otherwise does not impact any other patient rights. Things that are very simple and common: using a phone, having belongings, having the right to visitation. All patients who are placed on our type of medical incapacity hold should be provided with the contact information for patients' rights and also informed of the ability to object to this type of hold, to file a grievance, to complain to California Department of Public Health or the Joint Commission. We were proactive in making sure that they understand their rights. Does a medical incapacity hold allow physicians to treat the patient without consent? This is almost a hand-in-hand question, because most of these patients who need to be held involuntarily need to be held because they need treatment. This hold does not authorize treatment of any sort. Okay, there are other policies, other laws on the books that specifically address treatment in situations where the patient doesn't have capacity, and we refer to those. These are the policies and laws that at least exist in our system and are referenced to California law. Situations for acute agitation or violence, laws and policy related to surrogate decision makers, emergency medical treatment laws, court-ordered medical treatment laws, involuntary psychiatric treatment laws, and then probate and LPS conservatorship laws that all can play into situations like this and help to clarify where and when you can treat. Can a surrogate decision maker authorize a medical incapacity hold? Yes. If the patient has a capable, qualified surrogate decision maker, efforts should be made by our physicians to obtain and document that consent for the medical incapacity hold order. This is the type of documentation that we request from the providers who order such a medical incapacity hold. It's the things that you might expect: the evidence that the patient lacks capacity regarding this decision, the clinical circumstances and anticipated outcomes of not placing this hold or keeping the patient here, the patient's efforts or statements of wanting to leave and decline care, alternatives that might have been offered to the patient, any actions that were taken by the treating physician, such as consultation, or if they needed to, restraints and the justification for that. surrogate decision maker or any other legal authority who provided consent to detain, and consultation with other parties at greater than 72 hours. And I think finally, when should a medical incapacity hold be discontinued? So it should be discontinued certainly when the patient no longer meets criteria. If capacity has been restored to the patient and they wish to leave the hospital, the hold should be dropped. And if they wish to leave the hospital, you are now back to this situation of considering an AMA discharge. If the patient continues to lack capacity but is deemed otherwise appropriate or safe for discharge, no longer at grave risk for medical decompensation, or if the patient has a surrogate who, in good conscience and good faith, chooses to remove the patient from the medical center for any number of different reasons that we can get into. So we would honor that surrogate decision maker's authority. Okay, I'm going to stop there and leave this for later if we need to come back to it, because we have just completed our 1 year post-MIH policy implementation to say what happened after we studied the data 1 year pre and post medical incapacity hold. Paul, should I take questions or?
Good morning. My name is Ken Landis. I'm a pulmonary and critical care internist practicing at Marina Del Rey Hospital, which, as many of you may know, is now affiliated with Cedars-Sinai Medical Center and is ultimately slowly morphing into Cedars-Sinai West. It's my privilege and honor to introduce our next speaker, but since we're running a little ahead, let me throw in a little aside. I had an unusual and unique interaction with Dr. Ron Miller back in the 1980s when he and I both attended a week-long course in bioethics at Georgetown University at the Kennedy Institute of Bioethics. He and I were roommates, and I can tell you Dr. Miller was a very compulsive note-taker. And he spent the nights replaying recordings of the speeches and upgrading his notes. So at the end of that week, I knew a lot more about that topic, but was very sleep-deprived. Our next speaker is Pamela Stone Hamilton. Ms. Hamilton is the Executive Director of Risk Management at Cedars-Sinai Medical Center, where she has worked since 2009. Ms. Hamilton is a registered nurse, as well as a licensed attorney with over 12 years of clinical bedside care experience and over 8 years of law practice experience exclusively defending physicians in hospitals. She began her career as an Air Force nurse after receiving her bachelor's degree in nursing from Fitchburg State University in Massachusetts in 1984. After 4 years as an Air Force nurse, Ms. Hamilton went on to become a critical care nurse at UCLA and UCSD medical centers. She received her Juris Doctor degree from the University of San Diego School of Law in 1993 while working part-time as a critical care nurse. Between 1995 and 2002, she was a practicing medical malpractice defense attorney who defended both physicians and hospitals in the LA area. She then returned to bedside patient care in 2002 when she relocated to the state of New York for family reasons and began working as a bedside labor and delivery nurse. She achieved certifications in critical care nursing, inpatient obstetrical nursing, neonatal resuscitation, advanced cardiac life support, electronic fetal monitoring, and she is also a certified childbirth instructor. In 2007, Ms. Hamilton decided to integrate her nursing background with her legal skills and took a position with Yale New Haven Health System in perinatal patient safety. In 2009, she began her position with Cedars-Sinai Risk Management Department, where she handles claims brought against the medical center, among other issues. She is a certified professional in healthcare risk management. As you can see, she's quite qualified to present her topic this morning, managing competing risks in hospitals, the patient's right to leave or the hospital's duty to safeguard. Please join me in welcoming Pamela Stone.
Good morning, everybody, and thank you so much, Dr. Landis, for that wonderful introduction. And thank you, Dr. Schneider, for asking me to speak here. I'm thrilled to be here. This is an amazing topic, and I have to say, when Dr. Schneider asked me if I would speak, and it came through Stuart Finder, who is our clinical bioethics director at Cedars-Sinai Medical Center, and they told me the topic was medical holds, I said, okay, I have to be honest. I think I know what they mean by a medical hold, but I'm not exactly sure. So I, want to know what UCLA has to say because I want to make sure that I'm on the same page here. And then when I heard Dr. Chung policy that he developed, I was thrilled because I just think this is wonderful work in this area because this is an area that's always been so confusing. And as a risk manager, and here's my slide progression. We get called about this quite a bit. Okay, so first let me tell you, doing something. Okay, so just a little bit about Cedars-Sinai and my role. Cedars-Sinai Medical Center, it's a 950 bed. We have lots of outlying facilities, including just urgent. And then we recently purchased Marina Del Rey. Thrilled to So we're sort of growing, which is why I was so thrilled to see policy. Right. Love. Oh, I'm sorry. I do have a loud voice, but okay, I'll try to stay here. So, Cedars-Sinai, we did used to be an LPS designated facility. So we did used to have the authority to hold patients on a 5150. And when I started at Cedars-Sinai, we had that designation. And I think it was somewhere around 2011, don't quote me exactly. We did give up that, or we lost that LPS hold designation. So we're no longer an inpatient psychiatric facility. We don't have any more inpatient psychiatric beds, which means that our challenges with mental health patients are even greater because we have to place them in a facility that does have LPS designation. So, and our risk management staff is staffed by people like myself who have clinical experience, as well as we're all attorneys. We're all licensed attorneys with experience practicing law. and we have 2 nurse attorneys, and we have a physician attorney as well. So, and it's really helpful because we are in a way like the in-house counsel for the clinical people. So we get all sorts of calls about clinical situations, most of them urgent, that they need some help with a medical legal question, and that we, it's our job to help them. And I have to say, I find it very satisfying to be able to help, having been a clinical person myself, and remembering how challenging it can be when all you want to do is take care of your patient, and then you're stuck with this sort of confusing either ethical or medical legal kind of question, and you need it answered right away so that you can just do the right thing and take care of your patient. And our department also does take call 24/7. So we get called from the emergency department quite frequently. We get called from trauma surgery. We get called from security, you name it. We get lots of calls. And like I said, we sort of have to, these are real world problems that have to be solved right away. So that's why this particular area of the medical hold is very interesting to me. Okay, so typically what happens at our facility is most of these patients that we're struggling with what to do we hold them or do we not hold them? Usually they're coming in through the emergency department. And the way that it works in our facility, like I said in the beginning when Dr. Schneider asked me to do this, I said, I think I know what we're talking about with the medical hold, but it's not clearly defined. We have a process in place that I will talk about a little bit, and we have some authority that we rely on, but like Eric said, there is no clear law on this. There's some regulations that sort of pertain that we kind of rely on. And we have a few policies that kind of touch on this stuff, but we don't have a nice, clear policy, medical hold policy like Dr. Chung was talking about, at least not yet. Maybe we'll go in that direction. So in any event, what usually happens, we have a 24/7 psychiatric liaison team. So we have a psychiatrist who's in-house and also a team of mental health workers who, most of them actually used to be part of our inpatient mental health unit, and who now, which is great because they have that extensive, behavioral health background, and now they are consulted, whenever there's a question about what to do with this type of a patient. So psych usually evaluates the patient, and then they determine, do they meet hold criteria? And like Dr. Schneider was talking about in the beginning, that hold criteria is very specific. If you can't, if they're out on the street and they can find it to pick through the garbage and, get themselves nourished, then, guess what? They don't meet hold criteria. So those hold criteria are very specific, and it has to be due to a mental illness, right? So usually what we've been doing is we've been having the psychiatrist evaluate all of these patients, even if they don't meet hold criteria because of a mental illness, they are not danger to self, others, or gravely disabled. We still have the psychiatrist do the capacity evaluation. So we've been relying really on the capacity to make a healthcare decision. And this is the definition right there of capacity to make a healthcare decision: the ability to understand the nature and consequences of the proposed healthcare, including its risks, benefits, and alternatives, and the ability to make and communicate a healthcare decision. And those are the citations for the sections in the probate code where it's actually in there. I have that definition right on my bulletin board in my office, and I have it mostly memorized, but and I'm often reading that to psychiatrists, to emergency department physicians, to social work. A lot of the more complex cases that we have, like many of my sister facilities here, we have a team of people who's working on this. We have the people from bioethics, we have risk management, we have psychiatry, we have social work department, we have, of course, the treating physician and team. So it really is, takes a village to look at these situations. But Oh, in. Okay. All right. Got it. Thank you. Sorry, I'm a little bit of a Luddite here. Okay. So, like I said, what we have been doing at our facility is focusing on that definition of capacity. And under this section of the probate code, 4658, the primary physician can determine a patient's capacity. And like Eric was saying in his talk, really it's any physician who is treating the patient has the ability to make that determination as to whether or not the patient meets capacity to make a healthcare decision. We use our psychiatry liaison service whenever there is a question about that, because they're really more familiar with that test that I'm going to talk about in a few more slides, that you give to the patient to see whether or not they meet the definition of healthcare decisional capacity. Okay, so these are really difficult gut wrench decisions. Sorry. I use my hands. That's right. Okay, so like I said, these are very difficult decisions. I mean, it's very straightforward. When you have the 97-year-old lady who's, confused, and she thinks the president is President Eisenhower, and she just wants to go home and take care of her cat, and she's very confused, and that if she were to walk out, she would get hit on 3rd Street. Those are easy decisions to make. Usually the patients that we struggle with are the ones that can communicate well, seem to have good reasoning, they're alert and oriented, but yet they still lack capacity. And I'll explain a little bit about what I mean. So what I always tell staff when they call me, and we get calls sometimes in the middle of the night, is always do the right thing, So patient self-determination, which Dr. Chung alluded to earlier, that's a strong principle in the law. And if you think about the case law as it pertains to Jehovah's Witness patients, there's a lot of, in all different states, there are cases on this Jehovah's Witness. These people are people who are making poor decisions. Well, some may think they're poor decisions, right? Because they're making choices to not have a blood transfusion because of their religious beliefs. And some of them actually die because they are refusing a blood transfusion. Now, these patients, they have decisional capacity. They understand the consequences of their decision. So this self-determination, in my opinion, is best illustrated in the law when you take a look at those cases for Jehovah's Witness patients. So the right to leave against medical advice, that is actually codified in Title 22 CCR, this subsection here, specifically provides an adult with capacity the right to leave the hospital against medical advice. So this is where the struggle lies for the staff. Dr. Schneider was talking about how staff is just they in their gut, and this is sort of a principle, I think, just in American culture, that, the idea that you should make your own decisions about your body, about, what you want to do with your life, your liberty, right? There's a very strong principle of self-determination. And so that's what the staff struggles with, and I don't want to falsely imprison someone. I don't want to hold them against their will. And what you have to kind of encourage them to think about is, okay, yes, maybe we are exposing ourselves to a potential claim of false imprisonment, but we have to weigh that against the very real and very dangerous consequences of, if we allow this person to go who doesn't meet the test of decisional capacity, then we're putting them at real danger of severe disability or death if we were to let them go out on the street. So it's sort of, you're weighing two bad decisions, right? And so that's what the staff is struggling with. And at Cedars, we have a restraint and seclusion policy, and I'm sure many of the other facilities here also have a restraint and seclusion policy. This is under the authority of Title 22 and CMS regs and Joint Commission. And basically, these are the rules that say restraints or seclusion, which would be holding a patient against their will, are only justified when it's clinically justified and when it's warranted by patient behavior that threatens the physical safety of the patient, staff, or others. And there are a whole set of rules around making sure you use the least restrictive means and that they have to be assessed, very frequently. And so there's very strict set of rules around the use of this restraint and seclusion policy for patients who do lack capacity. So I think it's easier just to kind of talk about an actual example. So I have a hypothetical here for you. This is a 59-year-old female patient with venous stasis who was admitted for cellulitis, which anybody who's not clinical, that's basically an infection in the tissue. So she had this venous stasis condition that led to an infection in her tissue, which can be very serious because you can become septic, and I'm sure you all know that you could die from sepsis. So she was admitted in a very disheveled state with poor hygiene. She had with her an adult disabled child, a daughter for whom she cares. She wanted to leave so that she could focus on caring for her adult disabled daughter. Psychiatry was consulted for assessment of capacity for medical decision-making, including disposition or discharge. The patient was cooperative with medical care, but refusing transfer to rehab for further wound care management. She did not appear to understand her medical condition, insisting only that she has venous stasis, but not an infection. And that really is the key here, because in order to have capacity, you have to understand the nature and consequences of the proposed treatment and the risk, benefits, and alternatives of that treatment. You have to be able to make and communicate a decision. And in this case, she lacked the insight to be able to appreciate the true extent of her condition and what the risks were of leaving. And I'll talk about that a little bit more. And this particular patient had, although I would say there was a somewhat of a slight mental health component, her issues were she had some cognitive impairment due to what exactly, I'm not sure, but there was some cognitive impairment, certainly emotional issues around having to care for her adult disabled child her whole life. So these were medical conditions that were impairing her ability to make her own healthcare decisions. So as far as planning for aftercare, she appeared superficially to be able to express a logical plan, i.e. arranging for insurance coverage so that she can reestablish with her providers. So again, these are the tough cases because the staff is looking at this woman saying, but listen, she's talking about how she can arrange her insurance. This is future thinking. This is very logical. This seems to be a woman who we should allow to make her own decision. If she wants to leave the hospital, we should let her leave. We should let her leave. But the truth is that we have this ethical obligation to keep her safe. And if we let her leave, we are not keeping her safe. And if we delve into the decisional capacity and really give her that test, we'll see that she lacks decisional capacity because she lacks the insight to appreciate the consequences of that decision of leaving. So in the notes, this was one of the social worker's notes, actually. One can fully understand her desire to leave given her condition that her impaired child will be left alone. Anyone in this room who's a mother or a father would understand that, right? That emotional pull. But again, if we had let her go, not only was she putting her own life in danger, but she's also putting the life of that disabled child in danger, which she did not appreciate at all. However, she's unable to express the risk, benefits, alternatives of accepting or refusing rehabilitation. As such, the patient lacks capacity for medical decision-making. So that's the key. She was determined to lack capacity to make a healthcare decision. Therefore, we had the authority to keep her, the ethical obligation, of course, to keep her safe. And it sounds a little bit cruel to say, or crude, I should say, to say, well, which lawsuit would you rather have? the false imprisonment lawsuit or, the wrongful death lawsuit? And I say, well, never mind thinking about it in that terms. Think about it just in the human terms. What is the right thing to do? The right thing to do is to keep her safe, and to keep her child safe. Is there a risk that she could come back and say, you were falsely imprisoning me? Yes, of course, there's always that risk. But, what I always tell staff is put yourself in the shoes of a jury. And if you're sitting on a jury and, you hear that the healthcare providers were doing their best to keep her safe, what way are you going to rule? You're probably going to rule in their favor. Okay, and this is just a little bit of the note that was written, and this was actually done by neuropsych, I believe. And if you go to California Probate Code Section 813, there is a really good description of the criteria that's used when determining a patient's capacity to make a healthcare decision. And they break it down and they talk about these different categories. And so for this particular patient, they looked at the capacity to understand her treatment situation and her options, the capacity to evidence a treatment choice, the capacity to make a reasonable treatment choice. Was she able to articulate a reasonable choice? The capacity to provide rational reasons for making a treatment choice. She was unable to articulate a rational reason for making her treatment choice. And then does she, of course, have the capacity to appreciate the consequences of the treatment choice? The patient was unable to articulate the consequences of her treatment choice. Rather, the perseverative and guarded manner with which she discussed her future would indicate she's unable to adequately determine the severity of her condition or appreciate the consequences of the choices she has selected. So I think that was a good example of a patient where the staff really struggled on making that decision, but it was the right decision. And again, I applaud my colleagues for coming up with a policy in this area, because I think that really would help staff who struggles with these choices. And thank you so much for listening. And
Hi, everybody. Thank you for coming back for second half. So when, for the majority of my time, I'm an inpatient hospitalist doctor as an internal medicine physician, and only for a minority of the time am I a consulting bioethicist. It's kind of hard to speak completely from different perspectives, but during this portion, I'm going to try as best I can to talk from the perspective of being a non-ethicist hospital doctor, okay? And I think that during this portion, we'll see, but there might be some things which arouse some passions. We'll see. I thought about wearing Kevlar to, in case any fruit gets hurled at me or something. Once I was giving a presentation actually at Consortium about a patient's poor choices, and one of my colleagues said a really, really smart thing to me. He said that he had been taught that if you believe in patient autonomy, you have to believe in patient tragedy. And I went home and meditated on that. You can ask my wife. And a lot of what I'm going to talk to you about now is that I don't believe in patient tragedy. I accept tragedy reluctantly. I accept tragedy when I have to, but I think it's the worst choice for everyone involved. And that I think that even as a non-ethicist hospital doctor, it's my job to work against tragedy. So let's begin. You've already heard two cases. Now I'm going to present you a contrasting third, which is reflective of the kind of work I do in the hospital. In my hospital, I'm not talking from the perspective of being a government spokesperson. I happen to work in a government hospital. This is an 87-year-old man who has been living approximately the past 35 years in the Philippines. He's an American. He moved there. After living in several western states of the U.S., he spent several years traveling internationally until he finally settled in a somewhat rural area outside of Manila. For the past 10 years or so, he has been living with a young woman and her child, and a child by another man, and they are supported by his Social Security check. When the young boy recently developed an illness, which I don't know exactly what illness it is, the patient decided that he should seek out work in the States to get money to bring back to help take care of him, provide more funds for their family. His lady friend, who I'm purposefully not calling a girlfriend because I frankly don't know the exact nature of their relationship, but his lady friend helped purchase him an airline ticket one way to Los Angeles using his funds. So he was found wandering in LAX by airport police and brought to the hospital, to our hospital. He said he was looking for a junkyard in the valley where he once worked many, many years ago, but he had no idea of the name, address, phone number, what bus to take to get there, or who might be there, who might know him. In our emergency department, he was alert and oriented only to his name. We did a MOCA, which is the new standard for what used to be the mini mental status exam, and that was 15 out of 30. So he had a quite advanced case of cognitive impairment. He had only minimal ability to give a sketchy history of his life and his medical conditions. He was evaluated by a psychiatrist actually in our emergency department who felt he had dementia, was not mentally ill, and was not a candidate for a psychiatric hold. He was eventually allowed to leave from the emergency department. Several days later, he was picked up by police, wandering and confused, and returned to our facility after hospital discharge papers were found in his pocket that said who we were, because he didn't know where he had been. On repeat emergency exam by another psychiatrist, the diagnosis was again dementia, and he was allowed to leave again. Within 2 hours of this release, he was picked up by police a third time, now walking into traffic on a freeway on-ramp near the hospital. Now, this is actually a composite case of several. So it's not one real man who had all these things together. So some of you who might be familiar with some aspects of this case might say, well, that's not right. And you're correct, it's not right. So it's a composite. So he was now admitted to the hospital on a 72-hour psychiatric hold and found to have a urinary tract infection on lab screening, although he had no urinary symptoms. That's when they call me up. And they say, Schneider, you have an admission in the emergency department. He's a guy with urosepsis. And he's got delirium. He's delirious from his UTI. Treat his delirium, he'll get better, you'll be fine. He'll go home. So then I get to meet him, and I agree, okay, we'll try some antibiotics, see what we can do. So we give him 4 days of big gun antibiotics for what was actually a mild UTI. It wasn't actually urosepsis, that was wrong. And guess what? The antibiotics do Nothing, right? He wasn't delirious. He was never delirious. As a matter of fact, he had a trivial UTI, which was something that the emergency department used to hang its hat on to find a medical cause for admission. But the reality was he wasn't medically ill in an acute way with delirium. So he gets admitted. We look through his belongings. We find his lady friend's phone number in the Philippines. And once we got a medical team all on board, we all call her. Had a conference call. That was quite an arrangement to get permission to spend to spend hospital dollars on calling the Philippines isn't easy, but okay, we did it. And she was not sure that she wanted to have a role in his life or that he should have a role in her life. She complained about his stubbornness, her inability to take care of him. He wandered there. She could not say that he had dementia, I think because she didn't know what that was, but she kind of painted a picture of that there. She felt that she was helping him do the right thing by helping him come to the States and to help with her child. And what became clear was that the reality was that this had happened before. He had gone on other trips to us and actually been admitted to us for the same thing previously, but had never really walked onto the freeway on other times. So our incredibly dedicated social worker was actually able to track down some family using social media in another state where he had previously lived, and they had been estranged from him since he left for the Philippines, and were not ready to play an active role in his life either. So there was not family who was ready to step up to the plate here. His 72-hour hold lapsed, and further holds were not sought, and he continued to wander from the medical unit. And lots of what we call smart codes were called. So a smart code, I guess, is the equivalent of Eric's gray code. And this is the idea that someone is leaving who we're afraid about, and everybody come running, please, and help. Let's see. So when you're a primary care doctor, your job is to consult many people who might be involved in the case and to get their input. So let's talk about some of the input that I was given, okay? So talk to several police officers from different jurisdictions, right, who were involved in this case. And their perspective was, he is obviously confused, he is medically ill, and you need to take care of him. Do the right thing to take care of him. Don't involve us. Okay, now I'm not trying to disparage the police or their professionalism, but the idea was very much, he is not a criminal, he has not committed any crime, you need to fix this. Continued hospital releases in which we say, he's not psychiatrically holdable anymore, only inflamed their notions of what they should be doing as responsible officers, peace officers, and that that by continuing to release him, we were being irresponsible to society. Okay? And despite that, though, if we tried to keep him in the hospital and not inflame that if we weren't doing so, if we weren't holding him under the auspices of a legal hold, that we were again wrong. Because if he's not on a hold, they can't touch him. They can't do anything to steer him right to the right place. So, it was very much that kind of situation that even calling the police officer when he's trying to walk away is somehow illegal. Talk to my psychiatry colleagues, some of whom are in the room here. So their perspective was he clearly had dementia and he lacked capacity regarding his own disposition, definitely. He's a wander risk and a safety risk, for sure. He does not require treatment on a psychiatric ward. He does not require use of psychiatric medications. Staff should work hard to find a surrogate decision maker who can authorize secured placement for him, whether that be lady friend in the Philippines, family in the other state who don't want to be involved, or maybe a conservator. And their feelings about the 72-hour hold was that basically they did it because it was a desperate attempt to try to save his life, and they recognized that it was probably wrong and probably technically wrong, but ethically right, and that they wouldn't do that again on him because further holds were definitely illegal. So find a way to do the right thing that is not an LPS hold. How about nursing's perspective? We have some nurses in the room, right? Always important to talk to nurses who live with the patient, after all, most of the time. And their perspective was he is docile, kind, and gentle. He spends his time tidying his room, endlessly poring over the various paperwork he has collected in our hospital and in other facilities, other detainments, lots of paperwork to pore over. He is confused and unable to understand where he is, why he is here, or how we want to help him. He continues to agonize about wanting to provide for my adopted son. It's not his adopted son, but he says that. He wanders from the ward if not watched continuously, then he is unaware how to return. Use of a safety attendant is a costly resource. We can't use sitters, Dr. Schneider, in that way. Sitters are very expensive. My social worker, incredibly dedicated, hard worker. Dr. Schneider, he needs secured placement, but any facility which would take him would require consent by a durable power of attorney for health care to put him behind a closed door, which he doesn't have, or a conservator, which he doesn't have. He has neither. All family contacts are either ambivalent, estranged, and or geographically far removed. He is a good candidate for conservatorship through the OPG, the Office of the Public Guardian. Let's put in a petition for probate conservatorship, Dr. Schneider. Okay, let's go there. So, it takes me to where I am. So, in internal medicine training, we're taught to take care of acute illness. It's what we do in the hospital. Is he acutely ill? No. As a matter of fact, the way I was schooled is that he's not even medically ill at all, that his dementia is not a medical illness. However, you've already heard in the first 2 hours of our conference that dementia is not a psychiatric illness. So what I'm painting for you, the picture, is that we're in no man's land, okay? I will accept that it is an illness which affects the brain, which affects behavior, and that no one wants to own it. I'll just accept that. And he's under my care. The problem is to pursue the kind of remedy which he needs, which is probate conservatorship. He'll be in my care for up to a year and or more. Right? It's going to take a long, long time, especially if there are any kinds of red flags raised or dilemmas or delays. Could go longer. So what's happened is that the hospital and the hospitalist get confronted by doing care which we were not schooled to be doing. But we recognize that it's the right thing to do anyway. I speak to my friends at the Public Guardian's office, some of whom are in the room, and some of these issues came up. Well, he's not an LA County resident. I'm not sure that the Philippines has a way to conserve an American who happens to live there. Concerns that he last worked in another state 30 years ago. And maybe that other state should be responsible for conserving him. So we dutifully called them. And they laughed at me. Concerns that his pension was meant to primarily provide for his own care and not that of his family members, as you define family. And that with him being in a hospital here for a year, waiting for his ultimate disposition, why is his check continuing to go there? All these kinds of issues. In the meantime, I'm writing my daily notes. Now, a doctor's daily note, vital signs, subjective complaints, physical exam, detailed assessment and plan. I'm doing detailed physical examinations every day, because that's what you do for someone who's acutely medically ill. That's not him, but he's a round peg in a square hole. Okay, so I've already sort of telescoped much of this to you. What's a hospitalist to do? Conservatorship through the Office of the Public Guardian takes many months to accomplish. The patient required repeated smart codes if without a safety attendant. The patient's not acutely medically ill and requires no specific treatment. So what I'm trying to argue here is that to allow this patient to have left, to walk out into LA would be, I think, ethically wrong from the perspective of non-maleficence. And that even though there isn't specific law which tells me what to do here, I am ethically obligated to not shirk my duty. And that the doc who says, hell with it, if you can't hold him on a psych hold, I'm not putting up with this charade, he can walk, that ultimately is an abrogation of what a doctor's duty is. And here is where I'm starting to moralize more as an ethicist than, as a hospitalist. But certainly these are the thoughts that were going through my mind. So these are the kinds of cases which made me want to develop policy. And as Dr. Chung developed his policy at UCLA, in parallel, I kind of developed our policy at my hospital. And so what I have for you here is a pie chart which looks at sort of the world of patients who are lacking in capacity and for whom you're thinking about a hold. And let's try to think where our case might fit in. Is he clearly LPS appropriate? No. Is he clearly medical hold appropriate? Well, in the way that Dr. Chung presented a nice case of delirium, in which almost everybody would agree, you certainly must do the right thing and hold this person. I don't think our patient is exactly the same. Is this patient clearly lacking capacity and in danger if released, but unclear which hold is appropriate? Not really. I mean, it's not a case where you might say, well, maybe there's arguments for an LPS. Like, maybe the patient has schizophrenia and dementia, right? And so then you can argue which one of those are really a factor. But that's not our case. Is the patient clearly lacking capacity and in danger if released, but a surrogate decision maker agrees to safeguard the patient? Like, don't worry, Schneider, I'll take him home, I'll take care of him. No, that's not the case. Is this clearly lacking in capacity, but unclear if in danger if released? No, because I showed you he was in danger. So what I'm trying to point out to you is that even when we make great policies, there will still be cases which are unclear, at least for the toolbox that we have in hospitals. And I would assert that when we have our panel and our question and answer time, that there are many of you who will bring tools which you may know about and which you may use on regular bases to help with cases like these. The problem is, we only have a certain number of tools in the hospital and they're limited. So I think that my patient more or less belonged up here, but I don't know that I would use the word clearly. Maybe I would say hopefully, or maybe. Now, ha. Everything gets more complicated in government. This is our sort of version of the algorithm that was a little bit cleaner in Eric's presentation. And without having to squint to see all the details on this slide, if you turn in your books, you might be able to read it a little bit more carefully or clearly. But there's an important point that I want to share with you up top, which is that when we began thinking about this, I was working with a geropsychiatrist named Dr. Stephen Reed. And Stephen and I rationalized that this was really about the idea of consent for hospitalization. This wasn't really so much about the issue of hold or danger, that those were important issues, but that the central ethics point was, could the patient give proper informed consent for hospitalization? And many of you know that the issue of informed consent for hospitalization is in many cases, loosey-goosey process. It's more of a, please sign our waiver when you get admitted. But it's not a detailed clinical examination, and certainly a detailed capacity evaluation is not something we do on each and every person getting admitted to the hospital. But when you think about this scheme, I want you to hold that in mind. So we said that any doc who's a hospitalist like me, who's admitting someone to the hospital, ought to think about this statement up front on day one. After my clinical evaluation, I believe the patient has the capacity to understand the recommended treatment plan, which includes hospitalization, as well as any alternatives to the plan, including no treatment. I'm not sure that happens on a routine basis, okay? But we kind of think it ought to. And what we do is include 6 boxes down in the corner of content that we think the provider ought to be talking to the patient about up front. So those are the risks and benefits of hospitalization, of outpatient treatment, and of no treatment, right? And that if the patient can reliably think about that information, understand, appreciate, recognize, and communicate, then he or she has capacity. And that then the doc can answer, does patient have capacity? Yes. Now, if the patient has capacity and refuses treatment, up here we have an AMA, right? Makes it very clear. Otherwise, if the patient has capacity and agrees, wonderful. It's an admission to the hospital. But here's where we start getting into all the trouble. And if you follow those lines down along a patient who lacks capacity, but whom we may still be ethically required to hospitalize, that's where we come to the question of, does the psychiatrist feel that this patient is legally holdable per LPS law? Yes? Wonderful. Psychiatric inpatient hold, either on a psych ward or a med surgical ward. But if that's not the situation and the psych hold is not appropriate, then we start talking about the realm of the medical hold. And it's at that point where we say, we have an incapacitated, unbefriended patient. We don't have a surrogate decision maker who can agree to the hold for them. These are the things he ought to do. Social worker to search for next of kin, consider an ethics consult, consider conservatorship, get a psych consult, and complete a detention of incapacitated patient for medical hospitalization note, which is what our medical incapacity hold is. So that's kind of the process that took place in our hospital. And because our patient that I told you about is not going to be in the hospital and getting better in 24 hours, we didn't think that a 24-hour order made sense for him or for a lot of our patients, because that would mean for the next year, some doc like me is rewriting that order every day. So the question is then, what is reasonable? And what we interim decided was reasonable was that the order would not be time limited. It could be an indefinite order, but that there needed to be a committee which would oversee the use of that order, and that the committee could decide on an ongoing basis, is this still right? Is some doctor abusing this, or is it okay? All I can say to you is that that whole process is still under review in my hospital. That's what we've started working with, and it's our plans, but it's still all up for discussion, even though we completed a policy. Okay? So I think that's all I wanted to tell you this morning. Thank you very much. Chris? Well, this one you have to bend over.
Oh, no, I'm just thinking it works.
Oh, either.
She can use it if it works for her. Okay. Hello, everybody. I'm Chris Wilson. I'm a nurse, attorney, bioethicist, and very fortunate to be here to introduce our next speaker. Our next speaker received her bachelor's degree, magna cum laude, from the University of Southern California, law degree from Bolt Hall. She's been a clerk back a few years ago for Judge Harry Pregerson, and eventually worked her way through being a deputy public defender to finally being the appointed by the Ninth Circuit Court of Appeals as the federal public defender for the Central District of California. But moving on from that, she became, in 2015, the supervising judge of the probate and mental health departments of the Los Angeles Superior Court. And she has received numerous awards. I mean, if I read you her whole resume, she wouldn't have time to talk, okay? But she did, as recently as 2016, receive the Ernestine Stahlhut Award, which is the highest award given by the Women Lawyers Association of Los Angeles. And it was for her outstanding character, dedication to service, and significant contributions to the cause of justice. Oh, that's fabulous. I'll tell you why she's here. I'm an attorney, and I was trying to count the times I've appeared in probate court, and in my 30 years of practice, I think it was about 8 times maybe. So what did I do? You know, it's like we had a conversation out in the hallway earlier where we said, you know, if you want to know a good doctor, ask the nurses. Well, I figured I should ask my colleagues who appear in the probate court. And I asked more than one of them. And the overwhelming recommendation for this conference was, my goodness, you've got to get Judge Stratton. So please welcome the Honorable Maria Elena Stratton. Good luck.
Okay, it's so nice to be here. I'll tell you that you're all medical, and I'm a lawyer, or was a lawyer. And my father was a doctor. When I told him I wanted to go to law school, I thought he was going to have a stroke. So I get it. But I'm also here to tell you that contrary to what Dickens said, the law is not an ass. And so I'm going to tell you a little bit about how we deal with these situations in mental health court and probate court. And I'll tell you that I had that guy from the Philippines in my court yesterday. Exactly, not the same guy, but exactly the same fact pattern. The only difference was he was illegally here from Mexico. But he had spent 2 years in Kaiser on Kaiser's equivalent of a medical hold until the social worker called APS, and APS called the public guardian, and the public guardian came in immediately with a temporary conservatorship petition. And so I'm looking at that going, wow, I think I had that guy's twin yesterday in my courtroom. So I'm going to tell you a little bit about my experience so you can decide whether I know what I'm talking about. When I became a judge in 2006, I volunteered to go over to the mental health court in Los Angeles County. And for those of you who don't know, Los Angeles County is the only county in the state of California that has a specifically designated courthouse just for mental health cases. Not cases where, you know, maybe somebody committed a crime and they're convicted of the crime and maybe they've got some mental health issues, and so as part of their sentence, they have to do some kind of mental health issues. No, these are for people that have such serious mental health issues, you know, DSM diagnoses, that they're either incompetent to stand trial, and so their cases are sent over to this courthouse. Maybe they are considered mentally disordered offenders, and so they have to be civilly committed against their will, even though maybe they've already done their time for whatever sentence they've been given. Maybe they're sexually violent predators, and so they need to be locked up against their will in a state hospital. All the LPS cases, all the 5150 holds that are challenged by the patients after they expire, and then the doctor wants to extend it. Patient has a right to come into the Superior Court. We do all of those extension hearings. In addition, we do ECT petitions for patients that have been recommended to have electroconvulsive shock therapy. And we also do gun returns for people that have been diagnosed with mental illness and they want to get their guns back. So I spent 3.5 years over there just doing those kinds of cases. And I'll tell you that everybody in that courthouse is there, or kind of like lifers. I mean, the DAs are there for a long time. The public defenders are there for a long time. The private attorneys that practice there develop an expertise. We have psychiatrists in the lockup at the courthouse every day to do these psychiatric examinations. So you get to develop a little bit of an expertise in this area if you knew nothing about it when you started, which I didn't. After that, I did some civil stuff and then ended up in probate, where I've been for 4 years. Now, probate, for those of you who don't know, was the original family law court. Before we broke out family law into something else, probate did everything for everybody. Maybe you needed to establish a death or a birth because you didn't get a death or a birth certificate, or you need to establish a marriage because you didn't get a marriage certificate. You come to probate. You come to probate for your wills. You come to probate, maybe you want to get some remains released from the coroner's office for someone you know or someone you love. You come to probate. All that kind of stuff that happens in people's lives, apart from divorces and child custody, we do in probate. We do guardianships in probate. We do probate conservatorships in probate. We do dementia conservatorships, conservatorships for developmentally disabled people. And so you can see that we basically are just dealing with everyday lives. And so we see a lot of people with dementia because in this county, the public guardian won't do LPS conservatorships for individuals that are suffering from dementia. So they come over to the probate court and we get those individuals that are diagnosed with dementia. So I'm gonna switch from that for a minute as a background, and I'm gonna tell you that, as you probably know, the policy of the state of California is to scrupulously protect individual rights for people that have been diagnosed with mental illness or developmental disability. And ever since the Lanterman-Petra-Short Act was enacted in 1968, and the Lanterman Developmental Disabilities Act was enacted shortly thereafter, it has been the stated policy of the state of California to protect patients' rights. Now, why? Because, as you know, in the 30s, 40s, and 50s, there was a lot of abuses going on with people that were diagnosed with mental illnesses or developmental disabilities. They were committed against their will by family members, whether it was warranted or not. They were forgotten once committed. They had no rights to judicial review, and movies were made about it, and an uproar came, and in the 60s, the legislature decided they were going to pass these laws to grant these individuals rights, not just protect them, but actually give them statutory rights that both the medical providers had to respect, the families had to respect, and the courts had to enforce. So, given that, it kind of put a crimp in what the healthcare providers had been doing. Some were complicit with what the families wanted to do, some were not. They were just being used. But whatever the case may be, these rights have, I think, have been a thorn in the side of some healthcare providers. And I know when I was over in Department 95 doing 5150 extensions, a psychiatrist would come in and they would tell me how mentally ill this person was and how they needed to be held. And oftentimes they were mad because there was also a legal standard that had to be respected as well. And oftentimes they couldn't get somebody held because maybe the legal standard for grave disability wasn't met. But more often than not, it was a good, at least it was a good experience, because my particular philosophy, and I think it's the philosophy of the probate court and the mental health court, is that we are all so much better and so enriched when we collaborate. And I know that the philosophy of the mental health court is collaboration, even collaboration with DAs and public defenders that are usually at each other's throat. In that courthouse, it's collaboration with each other and with the court for the benefit of the patient. And I'll tell you that that is really the philosophy of the probate court as well. We collaborate with counsel for the best interests, particularly of the patients that are in there on conservatorship petitions, with an understanding that we have to remember that they've all been given these very special, strong rights by the state of California that we have to enforce and honor. So it's a balancing act. But when we collaborate, we come to the right decision. And I guess what I'm here today to try to convince you all of is that it's not a bad thing to have to come to court, because the collaboration makes us so much richer. And I'll tell you why. Okay, this one isn't picking up? Okay, I will. So there is a statute, Probate Code 3200, which I probably see those petitions on a weekly basis. And those petitions are under a code section, and this is what the chapter section is called: Capacity Determinations and Healthcare Decisions for Adults Without a Conservator. I think that's what we're talking about here. Adults who need to have medical care, they aren't classically mentally ill and that they don't have an Axis 1 diagnosis from DSM. They don't have a conservator, they don't have anybody to make decisions for them, and you as a healthcare decider, you have to decide what to do with them. But you've made a determination that they lack capacity. And for whatever reason, they're not cooperating. They want to leave, they don't want to have the treatment you want, they are running up around the hospital, they're not cooperating with you who want to help them get well. What do you do with them? You've made a capacity determination with your own healthcare providers. You've made a healthcare decision that you think is in their best interests. It's for an adult without a conservator. That's a Probate Code 3200 petition. And I see them every week. Now, it's an easy procedure, surprisingly, because I know that a lot of procedures aren't easy. Getting an LPS conservatorship is impossible. I will absolutely own that for many reasons. But this procedure is surprisingly easy because it basically defers to you as the healthcare providers. We judges, we don't know how to diagnose people. We defer to what you tell us is the medical problem and the psychiatric problem. And then we come up with a solution for you. And that's what we're there for, the judges. We are there to come up with a solution for you so you don't have to worry about lawsuits. And you don't have to worry about anything else. Because once we make the decision, it's all off of you and it's on me. What happens next? Typically, the patient is in a perhaps life-threatening situation, has been stabilized from whatever it was, but is still, in the opinion of the doctor, if they walked out on the street, they might hurt themselves. Either their medical condition would get hurt without treatment, would get worse without treatment, possibly life-threatening, or because of what's going on in their head, they might walk into a bus or over a train track or whatever and get hurt. Typically, the hospital has determined that they lack capacity under the code sections that you saw today. Typically, there's no family to go to, no surrogate decision maker, no powers of attorney. And typically, there's 2 declarations attached to this petition. So all in all, it's about 5 or 6 pages that are prepared. There's a declaration from the treating physician that just says what the medical condition is and why it's so serious and what kind of treatment is being recommended and why the patient and what the patient's doing about the treatment. And then typically there is another declaration, usually from a risk manager or from a psychiatrist, who says why the patient lacks capacity. This is what we have done to determine that this patient lacks capacity under the code. It's a very easy procedure. And I only get them from 2 hospitals in LA County, Harbor UCLA and LAC USC. And they come in on a regular basis asking for court authorization to keep that person there for the treatment that they think they need. They come in on shortened notice. I had one last week that came in Tuesday. We had their hearing on Friday, and I authorized them to hold the person until the hearing on Friday. In connection with such petitions, the patient is appointed a lawyer at court expense. The lawyers are on a panel that the probate court maintains. They are all experts in this area, and they know that if they're appointed on Tuesday for a Friday hearing and they accept that appointment, they need to go out there and see that patient Wednesday so that they can supply their report to the court by Thursday, so I'm ready to rule on Friday. So it doesn't have to be an onerous procedure, but it surprises me that only 2 hospitals in the county use the procedure. And it's generally 2 hospitals that come in represented by county council. But they do come in on a regular basis. And once that detention order is signed, putting the case on to Friday, then you all are off the hook. Now it's my problem if I unlawfully detain somebody. It's not yours anymore. So there is a procedure out there, and I'm sorry that more people don't use it. The appointment of counsel is important, and this is why I mentioned the thing about my dad, because my dad was like, oh, lawyers, I really hate them. All they do is sue doctors. So there are some lawyers that all they do is sue doctors, that's true. But these lawyers in the probate court are very skilled. And they're skilled. I used to say to them that if I could take any 20 of you and send you over to the Middle East, you would solve everything over there right away. Because they're very skilled at negotiation and they know the law. And typically, 99% of the cases, they go out, they talk to the patient, they convince the patient to stay voluntarily. Or they're able to work out a negotiation with the healthcare providers or the hospital, or they're able to locate family that nobody's been able to locate. They are, in my view, miracle workers. And they're free to the patient, and they're free to the hospital. And so it's a resource for you to use. If you're having trouble with APS, and you haven't tried to go through Adult Protective Services, it's not a bad thing to come to court. You will get a skilled lawyer to help your patient get through all of this. And, you know, the lawyers are there to protect their clients' rights, but they are not heartless. They are not there to just make sure that somebody gets out on the street no matter what. They negotiate with their clients. And it's a wonderful thing to experience because more often than not, I come in on the Friday from the Tuesday temporary setting, and the lawyers talk to the client, lawyers talk to the doctors, lawyers talk to the other side. Things work out, particularly when someone is in such desperate need for medical care. So I tell you that the law is not an ass because there is a procedure out there, and it's not used as often as it should be, but we would be ridiculous if we couldn't find a lack of capacity based on delusions that come from a urinary tract infection instead of an Axis I diagnosis. We would be insane, wouldn't we? To say, oh, sorry, we're going to let this guy go because he doesn't have the right kind of mental impairment. And 3200 just requires a mental impairment. It doesn't require an Axis I diagnosis like an LPS conservatorship does. So if you have somebody that's demented and is insisting that they need to go home, and they're not able to appreciate their risks and benefits of the treatment and not having the consequences of not having the treatment, they meet the lack of capacity definition, you can come in on a 3200 petition because they have a mental impairment. It's just that their mental impairment is due maybe to an infection or a stroke or a TBI. I had a young woman in a motorcycle accident a couple months ago. She was stabilized at Harbor UCLA. They came in on a 3200 petition because her family wanted her discharged because they wanted to do some witchcraft on her. And she was just in terrible life-threatening situation. They came in and granted the petition, they kept her, they continued the treatment. the lawyer talked the family out of the witchcraft, and it was resolved. But I mean, you get the weirdest stuff. You see it, I see it too. We're in the same boat there. You get the weirdest stuff going on. The case yesterday I had with Kaiser kept this patient 2 years on a medical hold, I guess. And then the social worker called APS. APS immediately called the public guardian. Public guardian came in on a temporary conservatorship petition. I still don't know how Kaiser justified holding someone for 2 years without any kind of court order. But that's for another day to find that out. So I guess I'm here to kind of make a pitch that I'm not so sure the medical holds that you're talking about insulate you from the liability you're worried about, if it's a liability issue. Because even the medical holds aren't really authorized by statute. And coming in on a 3200 petition would insulate you from that type of thing, and it would also give you the authority to treat as well as hold. Your medical holds only allow you to hold. They don't allow you to treat. This allows you to treat and hold, and it pretty much insulates you from what happened before if you held them pending the petition being heard. So I'm kind of urging you to think of that. I have heard from some people that, oh, this is a real onerous and time-consuming and expensive process. If that's what's holding you back from using this remedy, I urge you to call the probate court and call me or call Judge David Cowan, who supervises now, and we would be happy to meet with you and work out whatever your issues are with these holds, because they're fast and they're effective, and I think they do what the medical hold, you go even farther than what the medical holds you're proposing might do. I think that's all I kind of wanted to pitch you today. I have some concerns about the medical holds because I'm not sure that it really accomplishes what you need, and it may not solve all your problems. And as I said, you know, the probate department is more than willing to work with the hospitals to get rid of any obstacles you feel are there in getting you into court fast and efficiently. So that's my pitch to all of you. Thank you.
That's all right. I'll keep you all company until he gets here. Is Jonathan Sharon here yet? I'll tell you about him so you can get really excited. So when he walks in here, you'll know everything about him. And this will allow me to spend as much time as I wanted to, because I was up late last night reading so much about him and his blog, and I never read blogs. So I highly recommend that you look into this guy's blog. So let me tell you who I am. I am on the steering committee, and I'm the Bioethics newsletter editor. So please take a copy of that, because I hate to print those out and see them remaining afterwards. So take it home and read it, please. I am also a family physician, in addition to being bioethics chair at California Hospital for over 10 years. I teach at USC. Don't tell anyone right now. We're in the news. Hopefully you haven't heard about that. But I have an interesting career trajectory. I am working my way toward the gutter. Currently, I work at LA Christian Clinic, which is right across from the Mission, downtown LA. So I have to go past tents of the patients that I will see later in the day on this postage stamp of former single occupancy hotel where the patients come in and see us, and it seems very serene and safe, sort of, when they're in there, but then they get discharged many times to the street. So this topic that is very near and dear to me, and this person that you're going to hear from soon has a tremendous responsibility because he is the director of the Department of Mental Health in Los Angeles County since November 2016. He has 250,000 clients, and he has a budget of $2.5 billion. He went to school at Brown, undergrad, and then did his graduate work at the University of Chicago and Harvard, and did postgraduate work at UCLA. His prior work has been with veterans, and he's been described as a warrior for veteran well-being. He's worked with Volunteers of America. His contributions to the literature, and I couldn't find these, but I'm really excited to try, is on the science of sleep and sleep circuits in mammals, and also the psychotic process, for which he got an award, the Kempf Award, by his peers. His hobbies include surfing, and his blog, he said, I surf in the morning, I surf in the evening, and sometimes I just run or bike on the beach, my forms of meditation. And that's where we differ. I have no time to do any of those things. I'm amazed that this guy is so efficient. I do walk my dogs, but he just lost his Burmese dog. You'd be happy to know I even know that about him. I'm telling you, I've been stalking this guy. Another thing that is pretty exciting about him is that since he took over, apparently there's a place on Vermont and 6th, which is the Department of Mental Health, and it used to be surrounded by chain link fence and didn't look very hospitable. They took that down, and now it's supposedly quite inviting. I also work in that area, so I'm going to check this out. And he does peer-to-peer. Oh, here he comes. I'm telling you, I know exactly what he looks like. That's him. I told everybody about you. I've been reading your blog. So he says that the only way to connect with someone is to connect with your heart. Now, I have to tell you something. This guy comes from a pretty good genetic line, I think, because his dad's Ed Sheeran, who was a director of Law and Order, Hill Street Blues, one of my personal favorites, Moonlighting, and taught him about ethics, probably at his dinner table, as did my dad, who taught ethics as well. I am just hoping that if this gig doesn't work out, and I desperately hope that it does for the sake of my patients, my ex-cons I worry about the most, perhaps, because it's so hard for them to get jobs, and they're just so traumatized by their experience. But I know a medical school that could really use an ethical guy. Anyway, here he is.
Hey, everybody. Whew, I'm exhausted. Just actually was downtown at the NAMI Walk, which is a pretty special event. Sure. One of these guys over here? You can't hear me. Hey, Eric. Is that better? Okay. I was just saying that, yes, I am exhausted, and I'm sorry I'm a little bit late. I really wanted to see these presentations before to provide some context for my comments. I was at the NAMI Walk downtown, that's what I was saying, which was a pretty amazing event. And, you know, one of the things that became kind of clear to me after speaking with Dr. Schneider, who I haven't seen in some time, and reading through some of his materials, is that the Department of Mental Health, strangely enough, is not really in the hospital business, per se. We obviously have a lot of individuals that we care for who are in and out of hospitals, but even the county hospitals are not run by the Department of Mental Health. I have kind of found that a bit strange. It took me a little while to wrap my head around it, especially because the bulk of clinical work that I did was in the context of inpatient psychiatry and consultation. But in fact, going back to the late 70s, I believe there was an agreement that the Department of Health ran hospitals and that the Department of Mental Health would give them money to take care of patients who are suffering from psychiatric illness. So there are probably a couple of people in the county who are much closer to this topic than I am, although I'm engaging with them, I think, in a new way. And I believe that this department, for reasons that I think relate to today's topic and many, many others, including the connection between inpatient and outpatient, needs to take a much more proactive role. I don't have any slides. I don't know how much time I'm going to need. I'm really looking forward to the Q&A piece of this, but I do want to say some things. Just as with the psychiatric care that's delivered in acute settings, the care that's delivered to folks who are suffering from medical issues must always have their care driven, even if it's done in a paternalistic fashion from time to time, based on humanity, the humane approach. That always is the driver. And right now, because of recent activities at the board, there's a lot of attention to involuntary care. And those conversations are being driven by that fundamental theme. And I think when we talk about medical incapacity, we have to use a lot of the same fundamental principles in kind of driving our decisions about what we're going to do for an individual. And, you know, my experience of these issues, both at UCLA and at the West LA VA, were really that it felt like we were, when the situation arose that someone had a medical problem and the inability due to delirium or dementia or some other cognitive issue to make decisions, is that we were going around with tape and glue and string trying to figure out ways to make it work. And we do way, way too much of that. And really the only way in many cases that we get people care is by heroic personal efforts. And heroic personal efforts, as we all know, are not sustainable. They're actually very exhausting. So we have to set up systems and policy that supports the humane approach. With respect to you know, LPS, I think we are in the department, based on the board's activities, in the process of trying to get clearer definitions of why we do certain things around LPS law. We're trying to, in a robust way, deliver training to everyone that's interfacing with patients that have psychiatric illness in and out of the hospital. And as a part of that, we're also looking at probate conservatorships. And it seems to me, at a very basic level, again, if we're taking a humane approach as the driver, that we would be figuring out ways for folks who are in the hospital, who may be on their way to needing probate conservatorship, have very clear principles in place. And that we would develop processes for accomplishing that either are supported by regulations or new legislation. And I don't see any reason why we can't do that. And one of the things that's never really been clear to me is, you know, probate conservatorship takes a long, long time. So does LPS conservatorship, by the way, in my opinion. But why is it that when we see someone heading down the road to a legal assessment of the need for probate conservatorship, that they have to remain in the hospital? just don't get that. And I'd say the same thing about LPS conservatorship, and it's one of the things that we're going to try to drive. At some level, we'll try to drive it because of logistic concerns. The hospitals are jammed, and people get released and then they come back. But why can't we find appropriate, actually more therapeutic environments for folks who require care and get them out of the hospital? And hospitals are, with all due respect, not necessarily the greatest places. They are a source of iatrogenic illness. So I would invite those of you who are interested to meet with members of my team to our conversations around probate conservatorship, which are going to be starting within the next few weeks. And anyone that wants to get involved should reach out to me through Paul, and we will include you in those stakeholder conversations to help figure out how probate can help solve some of these problems if we re-engineer it. I wasn't here for what seemed to be some lovely conversations from the look of the slide, and I don't think I have probably that much more to add. I think that that Eric's work and the decision tree that he articulates is a great map for what we really need to do. I would also say that there's legislation which written by a guy who used to work at the county, I can't remember his first name, but Assemblymember Chen, who is suggesting that grave disability have medical deterioration added. And I think there's this gray area between probate and dementia and LPS and psychiatric illness that should not exist. It doesn't. We need to do something about it. Whether we create some type of a hybrid, whether we make it easier to add medical care on the LPS side. I don't know what the answers are, but there's no reason why we can't either drive new regulations, get rid of regulations that are constraining us, or frankly, get new legislation in place. So I don't think I really have that much more to say right now, but as I said, I do look forward to being asked questions here up on this panel with these esteemed colleagues of mine, some of whom I haven't seen for a while, including Paul, who I start to look more like every day. We are both sharing, and I'm not sure that's a great thing. Anyway, yes, I guess it is. And I'm happy if there's any questions right now on someone's mind that before we convene a panel, I'm more than happy to entertain any question. Right on.
And we'll sort of go through the questions. I just wanted to start. Paul had a mentor who said, if you believe in autonomy, you have to believe in tragedy. I had a mentor who said that people have the right to make bad decisions. The challenge is the line between their right to make a bad decision and the need to be protected from a decision that they aren't fully realizing or aren't able to perceive as not in their interests. And this is really the struggle always of finding that line, which not only blurs but gets a little windy at times with that. So thank you all. This was very interesting, and I think we'll have a lot of questions, and I'll just try to go through to find some that are representative. The first is for Judge Stratton. Can you speak on the concern that if a patient has ever had an LPS hold, the probate court will send the case to LPS conservatorship, especially if it becomes clear that previous LPS holds were inappropriate, how to prevent this kind of back and forth? And I'll just add on, we had a case once of a patient who had prior LPS holds. She now had become elderly, had had some sort of a brain injury, and was unconscious. But we could not get a probate conservatorship to make decisions for her, and her psychiatric background was basically irrelevant at that point.
Well, I'll just tell you that don't have the authority as probate to establish an LPS conservatorship. Petition to start an LPS. If I have somebody in my court I might say to the conservator, if you talk to the public guardian about appropriate, and I can't force the public guardian to. So once it lands in my court for probate conservatorship, it should stay there, unless for some reason the public guardian decides to come in and.
So I will say at my facility, one thing that we have is it's actually getting through the OPG office, in that we contact their investigators to do it, and their probate investigator will kick it before it ever gets to court.
That's right, and that is I know that's a NAMI concern, that it's only the Office of the Public Guardian that can bring LPS conservatorships. Judges have no authority to say to the Office of the Public Guardian, file that petition. All we can say to them now under a new law that went into effect in January is, we want you to investigate to see if maybe one's appropriate. But I had a case a month ago where I said, I want a report from DMH to see if this person's appropriate for an LPS. The DMH report was awesome, came back, and it was very detailed. And it said, yes, this person should be on an LPS. And I looked at the public guardian representative, and the lawyer for the public guardian said, we're not filing, and you can't make us. I said, you've got this report here that basically backs up a petition. We're not filing, and you can't make us. And that was true. So I ratted him out to the Board of Supervisors. Because that's all I could do. I couldn't force him to do it. I had another one Friday, yesterday, where I had referred it to DMH for an LPS evaluation under the new law. Got another awesome report back from DMH. It recommended that an LPS petition be filed. In this situation, the lawyer was a little more circumspect, and she said, well, we'll put one of our investigators on it to see if we're going to file. So it wasn't an outright no, but it wasn't an outright yes, but it was, I was okay with that, so we put it over a little bit to give them more time to decide what they wanted to do. But it is a problem with the LPS law. On the other hand, it was generated by abuses of family members coming in trying to involuntarily commit people to state hospitals, sometimes because they needed it, sometimes because they just wanted to get rid of them. And before the LPS law was passed, those people would be committed and they were gone forever. They got no judicial review. They were just out there. So it's a balance. And whether there's going to be legislation to allow family members now to file LPS petitions, I don't know. But it's a balance.
Great.
Yeah,
Doctor.
if I could, can you hear me? Yeah, the issues that come to the board come to me pretty quickly. And I think the board is right now very committed to, I would say, expanding the capacity of the public guardian for both probate and LPS, based on the fact that there's, you know, we have a lot of people who are suffering and are incapable of kind of managing their affairs, and I would hope, as we expand our capacity, are able to become a bit more flexible and inviting to those people who have needs and are referred. One of the things that may also occur is that we're looking into, and again, I invite everybody here to participate in these conversations, because we are now at a time when things are relatively plastic, and they're not always, and there's a lot of board support to be creative. Of how the referrals are made, and whether or not there are other ways to, I would say, be more effective and streamlined. That's certainly my goal. And I know that there has been a new law recently that's relevant here that the judge is referring to, and I would hope that we would figure out a way to be much more effective in leveraging it. And those are probably conversations that we should have between the public guardian is in itself an entity that reports up into the Department of Mental Health, but there is, I would say, sometimes a healthy and maybe sometimes not healthy separation of those two entities. And I'll also tell you that in some counties, the Office of the Public Guardian is not in the Department of Mental Health because some folks would say that it's a conflict of interest.
Yeah. Dr. Chung, you had then Paul.
My own experience professionally as a psychiatrist involved in these cases is that the interaction with Office of Public Guardian is often one of seemingly deliberate distraction to move between one court and another to extend out the time in some cases, where conservatorship is not necessarily viewed by the Office of Public Guardian as a good endpoint for many of these cases. Their interest is in not conserving in a lot of the situations. And so moving back and forth between the courts with, as we've heard, months at a time, creates a setting where the hospitals may just let the patient go. And I think that's just an unfortunate current reality of the way that it plays out in the hospital setting.
You know, in regards to the question about a patient who had an LPS history, but was now far removed from it, right? I'm doing a lot of reminiscing this morning, and I'm remembering back to when I was real young and growing up in summer camp. And the summer camp had an Olympics where the whole camp was divided up into countries, and we would do, games, sports. And what they told us was that, hey, we do Olympics because other camps on the East Coast do something called color wars. And we don't believe in that. And I said, really? What's a color war? And they said, well, basically the whole camp gets divided up into red or green. And it's the red people against the green people. And you fight. And they get nasty. And so we don't do that. And it seems to me that what exists now in between the LPS process and the probate process is a color war. And that our patients are getting lost in the fight. And that the collaborative process that Her Honor talked about exists in certain microclimates, like in an individual courtroom, and I believe that it does, but I believe that in the macro system, there's no collaboration.
Getting into the courtroom. Okay, back to our questions. This one's for Dr. Chung. Why use a medical hold if there is a legally recognized decision maker who, by definition, can make healthcare decisions for the patient when they lack medical decision-making capacity? Can the surrogate not provide consent for anything, including detention, and does the law specify or prohibit that?
And there's, as far as I understand, no specific law that addresses surrogate decision-making about detention of a patient in the hospital, though it may be subsumed and implicit under surrogate decision-making power in general. The necessity of the medical incapacity hold is, as I pointed out in the case scenario, driven by the timing and the urgency at which these happen. Cindy's case happens at 2 a.m. and she's walking out of the hospital with wires on her head post-operatively. And yes, it is ideal to seek surrogate decision makers, but it is seconds actually that the decision has to be made whether to hold the patient in the hospital or not. That's the absolute necessity of the medical incapacity hold. We have written into our policy, as you have in your booklet, specific directions about how to contact, when to contact, how to document about the authority of this surrogate decision maker, and defer to the surrogate decision maker authority whenever it is possible and appropriate. the times at which these happen, the surrogate may not be available or there may not be one available in general. And I think it extends further beyond to the process of 3200, PC 3200, in that at Friday night or Saturday morning at 2 a.m., you can't get a 3200. And so what are you going to do when the patient is continually trying to leave post-operatively after a brain surgery, and all the risks that are inherent in that?
I just wanted to add that I completely agree with what Dr. Chung just said about the fact that the policy that UCLA has created is for those situations that are urgent, and that something needs to be done right now to provide authority to hold the patient in these situations. But that we always are looking for a surrogate decision maker for, all of the other care that needs to be provided, right? What if the patient needs to go to surgery? We really want to get a hold of a surrogate decision maker for that purpose as well, right? So that's always kind of going on in conjunction and in the background. And we also at Cedars have a policy for patients who lack representation, so the unrepresented patient policy, because there are some of these patients who literally have no family and no one who can make a decision for them. And so we use, in that case, we use patient's best interest. The primary physician can actually be the decision maker for decisions that are not invasive procedures, but for surgery or something a little bit more elaborate, we have an ethics committee that makes the decision for them. But that those two things are always going on, that the decision to hold the patient, needs to be made urgently, and one set of criteria is used, and then we're always looking for a surrogate decision maker as well.
Yeah. And just to follow up on that, another question for Dr. Chung and Ms. Hamilton both. As a practical matter, how do you accomplish the goal of physically keeping a patient in the hospital when he or she insists on leaving? And are you physically able to do so? I mean, do you tackle him in the hallway?
Only if you have to. The true answer is the least restrictive means possible. And that means everything before you have to tackle a patient and keep them from leaving. Everything before you have to restrain any limb whatsoever. Everything before you have to close the door and stand in front of the door, talking to them, attempting to redirect them, drawing in family members, distracting them, giving them food and crackers, whatever it'll be before you have to put a person into a restraint or seclusion situation. But if you have to, then that's the default at the end of the day.
And I totally agree with what Dr. Chung just said. Everything's shy of placing hands on the patient. Obviously, you want to try to avoid that at all costs, but sometimes you have to. We even have our security people who are trained in de-escalation techniques, minimal use of hands-on to the patient possible. Like he said, coerce, use food, whatever you can do to keep the patient from leaving. In the most compassionate way possible. And those regs that I had up on my slides, those are the regs in the Title 22 and whatnot that say that you have to use least restrictive means. So a chemical sedative, use of a chemical sedative is more humane in many times than having to put, wrist restraints or chest restraint, a posy restraint, something like that on. So we would do that if we had to. It would be considered least restrictive means.
Great, thanks. This one's actually probably for most of the panel. What do you do with patients who meet LPS and/or 1799 criterion, who also have medical comorbidities that need medical care? At 24 and 72 hours, the LPS hold expires. They may or may not be medically stabilized, and yet an LPS facility will not accept them due to their medical issues. This is a big no man's land many of us confront regularly.
Yeah, just a quick comment about that. I had mentioned this new legislation, which I think is in many ways driven by that scenario, I think it follows suit that individuals who are unable to feed themselves or clothe themselves. Who are allowing themselves to, who are not able to manage their health condition, their physicality, ought to be falling under some type of legal jurisdiction.
Practically speaking, the way that we handle those situations is asking what is the most legal thing to do. So if the patient meets criteria for LPS hold, we will always default to placing an LPS hold. Behind that is if they are unclear whether they continue to meet that criteria, we'll ask the question of whether they need medical hospitalization or psychiatric hospitalization. What is the clinical need now? Because LPS holds indicate that a patient needs to go to an LPS hospital, an LPS facility for further evaluation and treatment. For the medically ill patient who might have coexisting psychiatric condition, that might not really be the most appropriate thing for that patient. Where they need actual, say, medical ICU care, in which case we may default back to the medical hold, the medical incapacity hold. It wouldn't also be uncommon that we move back and forth depending on what the clinical scenario is, and that we now have the flexibility to do what's right for the patient using the most appropriate tool.
I would just add that I agree that that is a really, really difficult situation. The patient who, and that's true at Cedars because we don't have the LPS designated, we don't have that designation, but we have many patients who need to be held because they have a medical situation that's urgent, but yet they have mental illness. And the 13200 petition that you say we do them rarely. It's true, we do them rarely, but the one that I can think of was a person who really needed, actually it was an amputation she needed to save her life, and but she had schizophrenia and would not take her psychiatric meds, and as a non-LPS designated facility, we don't really have the authority to force psychiatric meds on a patient unless it's an urgent situation, like they're extremely agitated and just to, for their own safety to sedate them. So that really was a struggle, and those are tough situations, and we did go to the court for help on that one.
I'll just comment that in almost 30 years of doing this business, I also have experience with 3200, which was also an amputation of a leg in someone who was schizophrenic. And let's just say that the best I can comment is that I use the tools which are available to me in my toolbox, and 3200 is not a readily available tool for a whole variety of reasons which are very complicated. I wish it were.
We in our hospital talk about 3200 a lot, and we rarely use it, and you know that. In part because it's not necessary at the end of the day. If you get the patients to stay long enough, you can persuade them to the treatment that they need. And why need a 3200 when you can persuade a patient to accept the lab draw or the antibiotic or whatever surgical treatment if they're assenting to it, or you can find somebody who can consent on their behalf. But when they try to leave is when that becomes a problem, and you don't have the opportunity to then work with them over several days to bring them on board to the treatment.
This one goes to, here's another one for the judge, and it's again talking a bit about the 3200 and the conservatorship and the overlap. If a patient has dementia, we need more than detain and treat. We need conservatorship because of lack of disposition that will keep patients safe. So one reason patients stay in hospitals is we're not able to discharge them unless there's someone who can sign them in to a lower level of care. And so we need the conservator to sign them in. So are you suggesting we file a 3200 to detain? My added question is a 3200 to discharge, to get the discharge, a probate in lieu of a probate conservatorship?
No.
And I would suggest also the case you talked about of 2 years, we had one for 1 year. It wasn't that we detained the person refused to leave.
I just find it amazing because the hospitals are always complaining how expensive it is to keep the patients in, so why not come to court so you can get them out of there? But anyway, no, you wouldn't file a 3200 petition in that sense. You would file a probate conservatorship petition or a temporary conservatorship petition. The public guardian comes in weekly, having been contacted by a social worker at a hospital or APS. They have someone in the hospital, they're ready to be discharged to a lower level of care, and they need somebody to authorize that. So the public guardian will come in on a temporary conservatorship petition, which requires 5 days' notice, and ask for a temporary conservatorship so that they can get that person out of the hospital and into a lower level of care. You wouldn't file a 3200 for that.
Okay. And just to add for you, Dr. Sharon, is that we have a great deal of difficulty getting a temporary conservatorship if it looks like it's going to a probate conservatorship. I almost never get our investigators to go forward with a temporary.
Yeah, as I was kind of alluding to earlier, I think that's a problem, and I don't know why we aren't able to leverage that much as we, theoretically do with LPS. Although, again, for whatever reason, people tend to stay in hospitals and when they're on a temporary conservatorship of either type, and I would argue that that is not necessarily the best plan. In fact, if you come back to the driver being, what's the humane approach? I don't think that's it.
Agree. Okay, what would be done if the medical inpatient hold went beyond 72 hours and no surrogate decision maker is known or available, but the person is still medically compromised? So when you're, both for UCLA and for you, Paul?
Right. So I think Eric mentioned that there are criteria for when the medical incapacity hold should terminate, and that theoretically a hold could either be rewritten daily until it's no longer needed, or in my scenario, a hold is written once and a committee provides oversight about whether it's continued to be needed. So I guess the answer is that we would reluctantly continue it until it's no longer needed for as long as it takes. And maybe for the patient that I presented in my little talk, it might be a year long.
Go ahead.
I referenced in my talk that there's a 72-hour review that we built into our policy. That was an intent to do as much as we could to ensure patients' rights about this matter. That was not a fixed time stop where we could not continue 72 hours beyond that. It's more of a certification process that it continues to be appropriate to maintain a patient on the medical incapacity hold. I didn't show you my post-medical incapacity hold data, but the average duration of being on a medical incapacity hold is 4.4 days.
Great. What happens if the medical team, and perhaps even bioethics, agrees that a patient lacks capacity for the medical issues, but psychiatric consultant examines the patient and thinks that the patient does have capacity, or says that there is no psychiatric condition interfering with their capacity? And that's just sort of people's responses. I think we're doing a bit of sort of brainstorming. How do we manage? This comes up constantly.
So it's a great question. Maybe I can see a hand. Who asked? Thank you, Kendra. It's interesting. You probably don't know. I did write an article called "When Bioethics and Psychiatry Disagree About Decisional-Making Capacity." And what I found was that the typical reason for disagreement is that bioethics will approach the capacity from a relatively theoretic standpoint, okay, using the 6 boxes that I told you about, and it won't be predicated upon next steps. Now, I mean to cast no aspersions upon a psychiatrist or any of my colleagues in the room, But when they assess capacity, they have to be concerned about what it means to say that the person lacks. It's not theoretic, it's real, and they may now have to go to court. There will be obligations on them, maybe to transfer a patient to the psych ward, maybe to do LPS conservatorship, what have you. So the issue that I've found is that in those kind of cases, a psychiatrist is more likely than a bioethicist to say, I think the patient has capacity, and it's because the after effects of saying he doesn't have it are very serious, and I don't want to fight.
This is where law and clinical medicine are very far apart. And the criteria for placing a 5150 hold are legal criteria. They're not clinical criteria. There's clinical aspects that go into it, but the legal criteria is your danger to self, danger to other, or gravely disabled, specifically defined as inability to provide food, clothing, or shelter for oneself due to a mental illness. A patient can conceivably not be dangerous to himself or herself and be able to get food, clothing, and shelter, and yet not have capacity to understand the decision about their gangrenous leg, which would jeopardize their health and well-being. Whether you call that gravely disabled or not, I think it's up to you and how you interpret it and how far you're willing to bend the 5150 law, which is non-standard. There's no real approach to that. And the 5150 law says nothing about capacity as a criterion for placing a hold. So that's where I think we have to close the gap a little bit, where we're trying to close the gap.
Okay. So as a court-appointed conservator of the person, and the conservator holds medical powers, I've had problems with physicians understanding that the conservator, not the patient, is the decision maker. How can physicians, social workers, psychiatrists resolve their feelings about patient rights and legal court orders? So, very theoretical, but this challenge of getting the conservator recognized. Have you all run into this, and how do you approach it?
So how we approach it is, number one, conservators don't necessarily have carte blanche. They have specific powers that are authorized to them based on the court that they were granted those powers in, be it LPS court or probate court. And we approach it from a clinical perspective of, show me the papers. I need to see the court stamped authorized papers that prove that this person is the conservator in order to uphold the conservatorship power. It is not infrequent that a person says, I'm conservator, but they don't actually have authority. It has been expired. Something has happened, for especially in LPS conservatorship. So we approach it practically from that standpoint, teach our clinicians and social workers to read through what those powers are, and then make a decision about whether the authority that the person is making a decision on is covered under those powers.
Yeah, you know, again, one of the things that the department, given our role with the public guardian, is looking to do is to develop a robust and relatively uniform training across the county and all of the systems. And I would say that that beyond training, it's also access to information, which is really what Eric is talking about. And I think that needs to be built into what we do here to improve our ability to deliver care in a more timely fashion.
So one of the areas I commonly get involved in that relates to this question is the kind of disagreements that ensue about end-of-life treatment for patients who become conserved. And just to sort of give you an example, what happens is that a patient presents to the hospital in a severe illness, which may not be recognized yet to be end of life, but maybe close to it. And doctors, over a period of time, figure out that this is probably not looking good. and that this is an end-of-life situation, and an end-of-life care plan is made. Along the same time, the patient might have a dementing illness or toxic encephalopathy, reasons that he or she can't make their own decisions, and conservatorship is sought. Ultimately, conservatorship is, if the patient lives long enough, going to be granted. And then comes a reconciliation where we have to talk about whether the treatment plans that were made already are okay by the new conservator. And sometimes they're okay, but often they're not. And one of the common problems is that a conservator will more or less assert their authority to control that scenario, even beyond the roles of what I think a regular surrogate decision maker would do. And the conservator will come to it from the perspective of, I'm court granted, so I get to decide this. And in more of an authoritative way than, say, a wife or a husband would. And we'll try to sometimes step that down to sort of say that, yes, we recognize your authority as surrogate decision maker, but let's meet on a human level and not turn this into a test of authorities. But that's the practical level that these things usually play themselves out. I see it pretty commonly, and even more upsetting is that anticipating that fight, many doctors say, I'm not even going to make end-of-life treatment plans for my patient because I know that there's going to be a fight later once a conservator gets set. So let's just do everything until then, because it would be wrong to to do anything different until we know who's going to be in charge.
I will, if I may, I'm not on the panel, but insert a little bit of saying that I think a lot of these issues that come up and the animosity between especially hospital staff and conservators really get based in prior assumptions based on past experience and a lack of communication. Because there is an ability to work with the conservators, and many of the deputies are actually quite responsive and quite appropriate. I've done training with the OPG's office on making medical decisions, and there is a responsiveness to it. For us, when we have someone that an end-of-life plan is in place, we put that into the conservatorship request at the time we file the papers. So that is part of the medical information that goes forward to the court with the initial request for conservatorship. But again, it's learning on both sides to trust the other, because it becomes the same as you mentioned, your father's response. This is the legal side and the medical side, and we don't know how to play together. So let's keep our colors separate. But I think we need to open up to the need for communication and, in fact, insist on communication from the other side and not just accept that they're unavailable. And I think that there are problems on both sides, but we need to keep working on that one. I have seen tremendous changes in the 8 years I've been in LA County.
And the Office of the Public Guardian should get all the credit
Yep.
for having done that recently. And in my comments about what conservators might do in terms of changing end-of-life decision-making, I'm not assigning that to the Office of the Public Guardian at all.
But I'll tell you that if someone at the hospital, a doctor, wrote to the court and said, this conservator is completely messing up what we already arranged with the patient, or for the patient, or both, with the patient and for the patient. If a probate judge got a letter like that, they'd put it on calendar immediately, appoint counsel for the patient, have the lawyer go out, and we'd have a hearing on whether the conservator is acting in the best interests of the patient. But if nobody tells us, we can't ride herd on these conservators, whether they're private or public conservators. And oftentimes, it's the private conservators because they're the daughter or they're the brother, and they don't want to let go of their loved one, even though maybe the doctors recommended palliative care. Oh no, do everything possible. And so But if the court isn't made aware of it, we can't fix it for you.
On that note, that what Judge Stratton is talking about, we had a patient one time. The family member was not the conservator, but rather was the agent under the durable power of attorney for healthcare. And this particular person was for sure not acting in this patient's best interest, and also for sure was not acting consistent with the patient's expressed wishes, because we had some expressed wishes that were in a written document before the patient became incapacitated. And we did go to court and we did seek removal of that person, and the court, we went in ex parte, the court granted it immediately. And actually the patient ended up expiring before the long-term hearing was set, and the patient died in a peaceful way that was the right way that the patient wanted. So
Go ahead.
Just a quick comment on this one. I'm not going to argue that there are scenarios where there are conservators who are not acting in the best interest. Certainly there are, and there have been, and I think we've probably all seen that. But I also think that we don't do a very good job of providing the level of support and information to individuals who take on conservatorship. And that's another focus of the department. We need to make sure that individuals, particularly family members who take on that really important role, are aware of all of their different authorities, and frankly supported in other real ways, even things as kind of mundane as transportation. The other thing is that, and this I think is probably one that will bring about some lively debate, is who is, over the long haul, if there's no appropriate family member in place or other kin-like individual or trusted entity, who plays that long-term role? And could it be that someone with clinical expertise is taking over the conservatorship? In other words, does the function of the public guardian, does it make sense for the public guardian over the long haul to play that role? And this came up maybe a month ago. There were several individuals at a stakeholder meeting who were suggesting that the public guardian could have a more focused role on the assignment of conservatorship, but the longer term conservatorship could be handed off outside of their domain. And this will be a hot topic, but it's certainly something for us to think about.
Here's another question. Why would dementia not be a medical condition or illness, since it is an organ system dysfunction?
I just have two words to say. Color war. Yeah, so I'm afraid, and I speak from a perspective of only thinking I know the answer, that it's daunting to accept dementia as psychiatric illness, and that it would flood the LPS courts if allowed to do so, and that it is theorized that way. Now, my usual answer to a psychiatrist who tells me it's a medical illness is I say, so if you had a private practice and that patient came to your office to see you for writing Aricept, would you be able to find a DSM code for their psychiatric illness of dementia? And they say, yes. So then I say, well, then why isn't it a psychiatric illness? And they have no answer for me. So I think dementia, I think the point is that it's irrelevant to discuss whether dementia is a medical illness or a psychiatric illness, but that we are forced into the fight, and that people like Eric and I have to deal with the after effects of it. The fight is much less at our level and much more above our heads. But I have to do the best with what I have. I think dementia is what it is. It's certainly something that affects the mind, and in my way of thinking, that means it's a psychiatric problem.
Well, let me just say, as far as LPS, do you know the difference between an LPS conservatorship and a probate conservatorship for dementia is that LPS is designed for people who are theoretically going to be not cured, but managed. Their illness is going to be managed. So at some point, there's a hope they're going to get off that conservatorship because they're going to manage their mental illness with their drugs and they'll be off. For probate, it goes on forever unless somebody stops it. Now, right now, there's no way to cure dementia or even to really stop it permanently or manage it. It kind of progressively grows, maybe slowly, but it grows. And so a probate conservatorship, frankly, in my opinion, is more appropriate for a dementia patient, whereas someone with an Axis 1, diagnosis of schizophrenia or bipolar or whatever is more appropriate for an LPS because theoretically you can manage those illnesses and get somebody off the conservatorship if they stay on their meds, which is the other issue.
I need to do a time check because I came up here without a watch.
It is exactly 12:01.
12:01.
And we're good.
We're good?
Yeah, so initially we had through 12:45.
Okay.
I think we got started early and we'll probably finish up early.
Okay, but we can still take questions.
So you can go as long as it feels comfortable.
Thank you. I just didn't want people saying, God, is she ever going to stop? It's like, no, I have no idea.
Maybe we'll do this for another 10 minutes and we'll stop.
Sure. Did you, Dr. Sharon?
I think that Judge Stratton's point is spot on. I mean, it's really the issue of reversibility, for lack of a better term, and the need for a longer term assignment when that's predictably not going to be the case. But the whole issue of the term neuropsychiatry. I mean, this is a neuropsychiatric illness. It's because we can't really we're making distinctions that really, at some level, are not important. And as we understand more about the brain and about mental illness and the heritability of mental illness, which in many cases far exceeds genetic risk for medical issues, I think that distinction will become less and less important. But again, it is the use, it's the leveraging of legal authority to look at the longer-term trajectory of the implications that really, I think, drives that decision.
Here's a particular question for Judge Stratton. Licensed professional fiduciaries were not mentioned as part of the collaborative team out of your court. Is there a reason for this? Are they part of it, especially given their ability to be appointed conservators?
We use them a lot. They're just expensive. So if you can't afford them, then you don't get one because the court doesn't pay for the professional fiduciaries. The patient does, or the conservator, the conservatee out of their funds. So unless you you can pay for a private fiduciary, you don't get one.
Okay. Neil doesn't want to write his questions, so I'll let him ask one. Because you're in the front row.
Thank you. Actually, my question was asked. I was the one who asked the question about the definition of dementia being an organ system deterioration. So why can it not be treated like any other organ system deterioration, like, say, chronic kidney disease? And the reason for my asking this question is, if it is, would that not give there more flexibility to the healthcare system to dealing with these patients and use of medical hold in a dementia patient, where right now psychiatric doesn't work, medical hold works for a while? That's the reason for my question.
the ends, what are the limits? Well, I don't know. What are the limits or parameters of the options a conservator has in making treatment decisions? Are there any specific limitations or in deciding treatment?
Well, each conservatorship is different, and so as the panelists have said, it's important to look at the documents that establish the conservatorship to see exactly what powers have been given to the conservator and what powers have remained with the conservatee. Sometimes you'll get a conservatorship and medical powers aren't given to the conservator, because in that situation, the conservatee's fine making their own medical decisions. They just can't balance their checkbook or whatever the other issue is, or they can't stop letting people into their house, that they don't know. So it's just important to look at the papers that establish the conservatorship so you know what the judge has decided is appropriate and what isn't.
Hear me? Yeah. So there are some interesting end-of-life problems that revolve around the powers of the conservator. So let's think about a case where a patient is gravely ill, and you go to the conservator and say, it's looking really bad, and we don't think we can cure him, and we'd like to convert to comfort care goals at this time and enroll him in a hospice. I've had scenarios where conservators, particularly professional conservators, will quote a famous case to me called Wendland. And they'll say that Wendland says that we can't, our authorities are constricted here, and that we can't agree to allowing him to enter comfort care. And so what?
Clear and convincing evidence.
Say again, Teresa? Sorry.
Without clear and convincing evidence.
Exactly. So in the Wendland case, there was a man who was very disabled, who was in a nursing facility at I think in his 40s, and I think as a result of traumatic brain injury. And there was not the presence of an advance directive about his prior wishes for end-of-life care. And his spouse, who was a conservator, wanted to convert to comfort care and terminate artificial nutrition, and with the idea that he would probably die soon. And the case went up through various appeals, and ultimately it was stated that, or it was held that a conservator did not have that power to do that, even though it was a conservator who had medical powers. And this was because allowing the conservator to do that would allow, I think, other conservators to terminate the lives or prematurely terminate the lives of people who might not or should not die. The problem was my patient was terminally ill. Wendland wasn't. Wendland could have lived for decades. So there's a question, probably the lawyers in the room are much better than me at talking about whether we should read cases with narrow readings or with broad readings. But there are a lot of conservators who want to read Wendland broadly and say, we can't do that. You got to do everything.
And the irony with Wendland is that the wife was an undisputed decision maker till the sister and mother wanted feedings to continue. So the wife sought conservatorship so that in order to trump the objections of the mother and the sister. When it went to court, they limited the powers of the conservator in this decision, which a family member wouldn't be limited in the same way.
I just want to add that in Paul's scenario there, that when there is a terminal illness and the patient is truly terminal, and the care that is being requested would be futile care. There is a probate code section, and I'm forgetting the exact. It's something like 47. somebody knows it offhand, that basically says that a healthcare provider does not have to carry out the wishes of a healthcare decision maker when the requested medical care would be inappropriate or not within medically accepted standards or something to that effect. So that is something that in those cases we do rely on because we don't have to ethically carry out a request that we don't have to do harm to a dying patient. So I just wanted to add that.
Judge Stratton, I have a question for you that comes off of some of these. And you talked about the 3200, that it's quick and easy and doesn't cost. And yet when I call my hospital counsel, I've told that in 20 years they've never filed one. I've never had a risk manager suggest one. And my counsel, when I say, well, really, we should do it, they're like, I don't think we can. And I have to say, I came from a county that did not accept 3200, so I didn't challenge them too much because that had been my experience. But how would you counsel people to go to their risk managers and or hospital counsels then to pursue 3200?
Well, I was told that hospitals don't like to do it because it's costly because they have to pay lawyers. And if they don't have a lawyer and staff knows how to do it, then they have to retain a lawyer to do it. And I don't even know how to answer that. I mean, I just think you have a tool there that you can use that would, I think, solve a lot of your problems. So I don't know why certain hospitals do them and not. Yeah.
Bioethics, the primary brother who was not the decision maker. The psychiatrist willing to go, we didn't know. Had never gone from our hospital.
Well, somebody's going to have to.
Anybody go? The brother was going to take it.
Yeah, anybody can go. The statute delineates everybody that can file: parent, a child, a relative, a surrogate decision maker. It's all laid out in the statute. It's one of the first sections of the 3200 statute, and you don't necessarily need a lawyer to, Well, you have to look at this. I don't know. Do you know, Sharon? Susan, do you know?
Department filed the 3200 petition. Now, health services. And back in the day, we had charge nurses, we had
Right.
social workers, we had doctors, we had.
I had a risk manager the other day come in with one. It was a very, yeah.
Hospital representative is now a hospital representative.
Yeah.
Who was there with authority from the hospital in order to get the 3200 petition.
Right.
It sounds like there's not a giant delay. Like we think court, multiple times, having its day, having to come back. But you're saying
They use the ex parte procedures to get it on calendar, and in the meantime, there's an order authorizing the detention and appointing a lawyer until the hearing. And usually the hearing, at least county council asks for a hearing in 3 or 4 days, and they're accommodated.
I think that part of the good thing out of this conference may be that many of us might be able to do what Kendra is suggesting and might be able to learn how to bring these cases to the court's attention. I think there's probably a disconnect between what's going on in the clinical world and what gets brought to your attention, and there's obviously a process of percolation by which these cases come up to the court's attention.
Well, county council has it down. They have the whole procedure down, so maybe they'd give you their templates, but.
Calling up, requesting a temporary conservatorship when all that was needed was a 3200 petition. cooperative with the public.
I just, topics like this, I want to make an appeal to people that have a lot of expertise and a lot of experience to participate in the efforts at the county to look at public guardian and what we do. And, things that, processes that are in place that aren't leveraged adequately and other avenues are, inappropriately being explored. That information needs to come to us so that we can really act on it. And if we're going to spend a ton of resource going out and looking to broadly train and to develop communication systems, and we need to do it as well as we can. And we can't do that without people having that have the knowledge like the folks in here without your participation. So please send an email to Paul.
Thank you. Okay, I have one more.
I think it makes sense, but just the proviso that I would add would be that going to court is a public process, right? And to some degree it has a political meaning.
Well, let me make it easier for you. There's a lot of doctors who don't want to take a position adverse to their client, to their patient. And particularly in psychiatry, my understanding is, the psychiatrists want to be allies, have an alliance with their patient. They don't want to be at odds with them. So when a doctor comes in and files a declaration in court, it can be seen by the patient as treason. My doctor's now against me. And then the cooperation ceases. And so there is a kind of an institutional, distaste for possibly setting up some kind of confrontation between the patient and the doctor. And you can see why that would be bad if that happened.
Yes, psychiatrists always have as their first interest maintaining some level of alliance with their patients. It just makes the treatment go so much better. Psychiatrists have tons of experience with the legal system by virtue of what they do, especially in hospital settings. This isn't about psychiatrists. This is about medical docs. And no psychiatrist is going to volunteer to go down to court to do the 3200. If they're told to, they will. Who wants to take the time out of their day to go down and sit in court and argue this in front of the judge? Nobody really does. And this is about non-psychiatrist physicians stepping up to that responsibility as well, because these are medically ill patients. And that's, I think, a much bigger hurdle, actually.
Go ahead, Chris, and then we're going to close.
Apparently, Judge Stratton. Nursing facilities that are desperately wanting get him there. What do? I explained about 3200. The statute does have a list of people. Not finding the person to do it.
So a lot of food for thought today, a lot of hopeful solutions. I think a lot for us to take back to our worlds and share the information with, think about how we can implement these. So are we putting the information up anywhere?
From this conference?
Yeah.
Yet to be determined.
Okay. So look for, yeah. If you're attending for the first time, you'll probably be added to our listserv and begin receiving stuff. So if we can get it disseminated, look for it, you'll receive it. Thank you all so much, and thank you to our panel.